They left yesterday.
Yeah, and Valencia.
That's right.
That's a long way.
Well, Palmdale.
Yeah.
Oh, that's right.
Darla, do you want to go ahead and get started?
I think we should go ahead and start because
so.
we've got a lot of material to cover, and the one thing we are going to be recording this so that if you find it of value that you can use that recording, and then we can always send you some of the paperwork so you can train other people in your operations. Marjorie is our teacher. Marjorie has been teaching me and Carol and everyone I know for a long time. We're not going to go into how long,
No.
but she's a great speaker. She has many letters after her name, but if you have questions, because it's a lot of material, what do you want to do? Just ask the questions.
Ask the questions. That's all you have to do. Don't be afraid. See, there he goes. First one.
First one.
Hey, this more of a statement. This is kind of a logistical issue. I guess it's kind of secret how to get into the bathroom. So if you need to use a restroom, check with folks up front, and they'll get you the key codes to get in.
Oh, it's a
There's
magic
also
code?
one on the lobby.
That could be
Doesn't
dangerous
require-
at my age.
They said it will lock later this
It will?
morning. Yeah.
Okay.
So.
Well, yeah, you're in a
When the
seedy
protest
little
is
area
over.
here, so you got to really watch it. So,
Whoa. Serious.
okay. I just noticed. Okay, so start.
Okay. All right. Good morning, everybody. Thank you for taking the time and effort to get here and show up and all that other stuff. A lot of times when you're trying to run a company, you are so involved in running your company that here comes the insurance broker and says, we have to do this, that, or something else. And a lot of times it's like, why? You know, what is the purpose and function and why? And a lot of times you just don't have time to sit there for hours and hours on end listening to all about the why. So part of what we're going to talk about today is just provide a little bit of background and information in a very certain area that I think affects a lot of different companies. So this is all about just information. This isn't about criticism. It isn't about, gee, you should or should not add somebody to your insurance, or none of that. It is just, this is the pragmatics of what happens in the normal everyday life of running a company and running a business. So with that, here's our subject matter that we're going to discuss. Very briefly, we're going to talk about risk management and what it means to transfer risk. One of the major areas that a business is going to want to do for many, many different reasons is transfer risk away from themselves as much as possible. That's very important. We're going to talk briefly then about contractual liability, additional insurance, whether you are obtaining additional insured status from somebody else or they are asking for additional insured status from you. What it means when we ask for primary non-contributory wording, waivers of subrogation, and one of the big areas today is use of leasing, temporary staff and leasing of staff. Do some of you do that now, use outsourced employees? It's not as simple as you might think from a risk standpoint. So, at any rate, then there's a reference section in the back and some supporting documents back there. So, words. These are odd words, but they're words that are being used more and more in the world of business. Risk management. The management of risk, it is an analysis of the exposures that a company faces. It is intended to be a very organized approach to looking at what it is that could happen, both good and bad. I'm going to add a word to this, enterprise risk management. Enterprise risk management is viewing a company in a very holistic manner that says, if we do X, Y will happen. X could be bad, Y could be good. Either direction. So making decisions on if we acquire a new company, we're using up resources, but the result will be an expanded presence globally. You know, whatever those decisions are. That's a risk to the company. So it isn't just risk of loss. From an enterprise risk management standpoint, we look at both good as well as bad results. So we look at pure loss exposures in the world of risk management, and in the world of enterprise risk management, it expands out a little bit beyond that. We're going to focus today on two areas. That is our risk control areas and risk finance. That's the only section that we're going to deal with today. So from that standpoint, we're only going to talk about things that can go wrong. Ways to push risk away from you, or areas that we might have to accept risk because we have a job that we want to get done. So the concept of risk management in and of itself is much bigger than insurance management. Insurance management is what Darla does every single day with every single client. It is looking at the right insurance at the best possible pricing for the best possible result. Risk management is everything that you face. So insurance solves part of it. It will never solve all of it. For example, Steve, are you one of the business owners that are here today?
No, I'm just a VP CFO for our company.
What does your company do?
Contractors Wardrobe manufactures and distributes wardrobe doors and shower enclosures.
I would imagine you enter into a lot of contracts.
We do.
We're going to be talking about contracts today. Okay.
He enters into the contract.
You get into the contracts. Okay, so it's all your fault.
It is. It's Brian's fault.
Whatever happens, there will be times where you will, by necessity, enter into a contract that has certain language contained in it, and you do so for a business reason. Part of that is covered by insurance. It will never all be covered by insurance, ever. So you take, from a risk management standpoint, we look at the whole contract assumption of risk as opposed to the insurance that's solving part of those issues. So we'll go into a little bit more than that. Insurance is considered in this concept a risk financing technique. You accept risk when you buy a building. That building can burn to the ground, right? Transfer of risk means I move fire risk over to an insurance policy. The insurance policy then pays if something happens. That's all it is. So it's a financing technique that is used, Mr. CFO, right? So you don't have to cough it up out of your own money, right? You're paying for that transfer to an insurance policy. So it works whether it's property insurance or casualty insurance or benefits insurance. It could be anything. So the concept then of risk management and the process that we go through, this is the hardest part of all of it. Identify the hazard. Identify the risk. Understand what exposures that client faces. You told me your company name. I'm trying really hard to figure out what your risk is, but I don't really know. I haven't seen it. I haven't been there. I haven't talked to you. I don't understand. I'm trying to understand Cardenas Market. I've been there, talked to you, seen part of it, right? But I don't really know every single piece of risk and exposure that that company faces. So we try to figure out what can go wrong. And I'm going to give you probably the biggest example that we've had in this country ever. I want you to go back 11 years. 11 years. Some of you were in high school, grade school. 11 years. We're going to go back to September the 10th, 2001. On September 10th, 2001, I want you to imagine identification of risk. I'm going to go in now and I'm going to sit and talk to Larry Silverstein. Larry Silverstein and his investors had purchased the Twin Towers in New York City. And they had done so the first part of July. Biggest land transfer in the history of the United States took place July the 3rd, 2001. Mr. Silverstein now is at risk of what? What kind of loss? Fire. Got that covered. Got sprinklers, got all this wonderful stuff. Security. We got security people. Go in and identify to this man that unknown terrorists can take over commercial jetliners, fly them into your buildings, and both of the largest towers that you just acquired are going to fall to the ground. That's identification of risk. On September 10th, totally remote. Do you understand? It couldn't really happen. I guess we could imagine it, but who would even think about that? Part of the risk management team did identify that as a possibility, not specifically to terrorism, but because they had had history in that city before with a private plane flying into the Empire State Building 60 years before. So it wasn't unheard of. It was just so remote, we don't have to worry about it. Identification of risk is the hardest thing to do. Once you identify what the risk is, to try to understand what to do with it. Example. Maria, you've got a lot of property. A lot of that property is in areas that could be subject to massive earthquake loss. Have a big earthquake, have no more building. Does everybody buy earthquake insurance then? No. Why? Because they keep hoping it's never going to happen. And it costs a lot to buy that insurance. Do you know why it costs a lot to buy insurance for earthquake? Because the probability is very high. And the probability that it could happen over the course of a span of 10 years is exceedingly high in certain areas of the country. So, identification of risk. Good morning. Good morning.
Good, yourself?
Good, fine, thank you.
Good.
Identification of risk, then understanding what to do with it. Do we retain it? Do we try to transfer it to somebody else? Do we try to reduce it? To avoid it? To do anything that we can so that our company doesn't fail? There have been a lot of studies for many years. All of the studies point to very close, the same percentages. If a business faces a catastrophic loss, whatever that catastrophic loss is, will it survive? Less than half survive. Less than half. Every single study for decades has said under 49% ever recover. Ever. Of those that do stay in business, 2/3 of them are gone in 2 years. So, that would tell me, would it not, Mr. Jack, identify the biggest, worst catastrophic losses that you could possibly have? Wouldn't that make sense as a business owner? Figure out what to do with it. Avoid it, reduce it, do anything you can to control it, transfer it to somebody else, or transfer it to insurance. You've got a lot of choices on what to do, but you have to figure out what's the worst that could happen. In your case, it might be you lose a contract. It's the biggest contract you've ever had. It's going to allow your company to grow, by maybe 2 times in the next 12 months. Loss of that could be catastrophic. Could it cause your company to fail? We don't want to think that way, right? So it isn't just physical loss. It could be loss of contracts, could be loss of a location. It could be a lot of different things, but we have to figure out what to do with it. The most common method of trying to deal with it is we retain it. I don't want to buy earthquake insurance because it's too expensive. Okay, we just won't buy insurance, which means by definition you've retained the risk, right? You hope it doesn't happen. You've retained the risk. The other common mechanism is we transfer what we can to insurance. And that means insurance becomes, by necessity, a very big portion of what it is that you're doing every single day within your company. The area that we're going to really focus on today are contracts. Entering into any kind of business contract. It could be a contract, something simple. We're going to lease our IT equipment. It could be something as we're going to lease for the next 30 years a building location. It could be that we're going to lease people. It could be that we're going to lease a fleet of autos. So it could be any kind of contract that we're entering into. This would be your area as well. Right? Not manufacturing. Do you actually manufacture these products as well?
Yes, we do.
Okay, so this is you. Would you have ever a sub-manufacturing agreement? You know what I mean, where somebody's making a component part of yours?
We typically don't, but there's a small aspect to it.
You could, right, a small piece. Purchase orders, people that are buying those products. Who's buying it? Where is it going? How is it getting there? And who's responsible for it? Leasing, right? You guys are involved in a lot of leasing exposures. Those leases, in some cases, you're entering into them, and they've already been in existence for years. You're taking them over on a sublease situation. So you've got all different kinds of areas where we could really have difficult situations that we're getting into. Difficult from not just business, logistics, trying to figure out and making sure that we're getting what we really need to do with the price that we need to do this for, but also what are you accepting and what are you going to agree to do within that contract. So within the contracts, here's what can happen. Anytime that you enter into a contractual relationship with somebody else, there's kind of a truism that I really try to remember. I go to lease a vehicle. The less I really want that car, the better the lease I'm going to get. Does that make sense to you? The more you want something, the more you need something, the less bargaining power you really have. There comes a finite point that I'm not going to get my way on that auto lease because it's kind of already set up. but I can get part of my way. When you're entering into a lease of property, property owner has property that you absolutely must have, and they know. They've got you over a barrel. You have much less negotiating power at that point to get your way. Pricing, terms of the agreement, but also responsibility for who's going to do what. So for example, if I enter into a contract, and let's just keep it simple. I'm going to enter into a lease of a building, okay, a part of this building. Could you say to me, so Marjorie, if you're going to come into my building, you are going to pay for any loss or damage that happens to my building while you're there? Could you say that to me in a contract?
Sure.
Happens all the time. What did I just agree to do? I just agreed to pay for anything. Many years ago, I'm not sure what that is, many years ago, I signed my very first lease. Well, actually, I didn't sign it, but I got it. I got it handed to me. I've now moved into my first office. I've got this lease in front of me. This lease was actually created by my attorney. My attorney happened to be also the attorney for my CPA. How'd that work? Well, because I knew everybody. So we had my CPA, we had our communal lawyer who gives to me this lease, and I'm going through and reading it, and it says, while I am there, I am going to be responsible for any loss or damage that happens to that property while I'm in that property. And I called him up. I said, Pat, are you kidding me? I am never signing this lease. And he said, well, why not? It's just a standard lease. I swear to you, that's the words he said to me. I said, you're actually saying those words to me? And he said, well, yeah, what's wrong? And I said, here's what you're asking me to agree to. If there's an earthquake while I'm at this property, you have just said, I'm going to fix your building. I am never doing that. And he said, well, we don't intend that. You ever heard those words before from lawyers? We never intended this. And I said, good, fix the lease. I was there for 10 years. I never had a lease. For whatever good or bad it is, they just never got me a revised lease. So I guess I was on a month-to-month. I'm not sure what I was on until I finally outgrew the space and I moved. I cannot tell you how many of my clients would sign leases that would say exactly that. You can't do that. That's not appropriate. Now, had I had to have that property, I would have signed that lease and just gone on. But you have to look at what kind of risk are you accepting. I was not willing to pay for earthquake damage to property that I had no control over that loss. You give me a lease that says, if I burn it up, I'll pay for it. I'm your girl, right? But unless it's my fault, that's never going to happen. I want you to carry earthquake insurance if you want on your building, but I'm not going to pay for it for you, right? I'm not going to fix the damage for you. So when we come in and we look at contracts, we're not looking at insurance issues. Darla, when you get copies of contracts, do you look only at the insurance section?
No, but unfortunately, many times when I get a copy of the contract, they've already been signed.
Okay. I have a number of clients that I work with. I'm not their insurance broker. I am their insurance consultant. That's a very different animal. And so one of my clients is a very big property owner. We've got a lot of tenant leases that we look at. We've got a lot of other leases that I can't identify because then you'll know who my client is and I can't say that. But suffice it to say, I'm embarked now on this rather major project where we're going through and we're looking at all of the leases. We're also creating standardized lease language because it's all over the place. The language on these different leases are all different. There's no set standards at all. And I'm going to give you a for example. This particular lease involves using a temporary staffing situation. They have used this company for 20 years. This is not a short, kind of business relationship. They really like the owner of this company. The owner of the company that provides the staffing services to them. They understand exactly what the needs of my insurance is. In other words, they want that relationship to continue. They never had a contract that required that staffing company to carry any form of insurance at all. None. What, are you kidding me? Okay, now I didn't say that to my client. What, are you kidding me? Instead, they kind of recognized that they had a problem themselves, and they said, well, you know, we've been using this staff company for a very long time, and we need to create an agreement where we're going to get some insurance requirements in place. That took 3 months of negotiating. 3 months. And this was with a staffing company that we're their biggest client. Do you know what I mean? So she wants to work with us. So that wasn't the issue. She was afraid, because she didn't know any better, that she was about to spend a fortune for insurance. And that wasn't what happened. So I ended up having to talk to this lady's insurance person, which should never happen in the real world, let me tell you, ever. I'm my client's consultant. I'm not her consultant. Do you understand? But she was so concerned over this that it was really going to eat into her profit margin. She was going to have to raise the cost. The cost would be passed on to my client. You know, so it's a round-robin situation. I knew she had workers' comp, but what she didn't have were a lot of the things that went along with that to protect my client when her staff people are working for us. It was an agreement that had been in place for over 20 years. So, it's difficult and it's very challenging when you look at the entire picture of risk and how to deal with it. There's all these different nuances, you know. I can demand a lot from that staffing company because we're going to pay that woman almost $2 million this coming year. Okay, she wants our contract. But I can't make them so arduous that she ends up charging us back and increasing our costs by 50% to cover her increased overhead. Does that make sense?
Mm-hmm.
So we have to, you know, there's always this give and take and the push and pull in the world of business where we don't always get our way, but at the end of this process, I will guarantee you 2 things. Number 1, my client totally understands what she has. Totally. Number 2, we have gotten the minimum requirements adhered to, what we have to have. And my client is better protected for it. That was my end result, was that had to happen. So we look at contracts. Contracts or agreements. Contracts or agreements that are entered into where I'm accepting responsibility if I damage your property, or vice versa, where we could be looking at damage to other parties' property. The injury or damage to third parties, you know, not between us, but maybe somebody coming onto the property, or injury to your employers or the other party's employees. So, business contracts. Business contracts themselves, when we accept responsibility for payment of legal fees or defense expenses for somebody else, we call that an indemnity agreement. That's all it's called. To indemnify means to make somebody whole again. So, for example, I'm going to go back to my little staff leasing arrangement. One of her employees comes out, and while they're out working at my client's property, a visitor to the property is injured by that employee. Now that didn't happen because of us, but it did happen at our property. But it was caused by that staffing company's employee. So far so good? I don't want my client to have to write a check to hire a lawyer when we are sued. Because regardless of why that person got hurt, that person was hurt at our property. That person is absolutely going to file a lawsuit. They live in California, they have to, or we'll throw them out of the state. You know, it's like a law, okay? So, they've now gotten hurt on our property. They're going to file a suit against us. I don't want to write a check for the lawyer. I want somebody else to write a check for my client's lawyer. Does that make sense? So far so good? That's indemnity. That's all it is. If that person wins their suit, somebody else is going to write that check too. Because I don't want that coming out of my client's pocketbook. I don't want it coming against my client's liability program. All right? So the indemnification agreement, the indemnity agreement says that that other party is going to cover my client's expenses, my client's lawyer's bill, and my client's payment of damages to that injured person if they lose, or if that other party wins. All right? So that's an indemnification agreement. We might require the other party to accept that responsibility, and we are. I mean, that's just normal situation. And Steve, you said that you've got in in a very limited way, a sub-manufacturer that does a small component parts for you. If something went wrong in the creation of your product, it's now out as your customer, they've paid for it, it's been installed, it's whatever, and something happens where maybe the system collapses and hurts somebody, everybody gets sued. Come to find out, it happened because of that, whatever that little component part is. It's a little tiny part of that big old thing that you make. In your contract with that sub-manufacturer, what are they paying for? Are they paying for your defense, your damages in that event? Everything for you? You're sure?
Well, I don't know in that specific arrangement,
But it sounds like that's right.
That's what we would be working towards, yeah.
That's right, and that's a reasonable thing in business. That's not unusual. Does that make sense? It's a logical thing that says, look, you're giving us a product that goes in our product. If something goes wrong with that, we expect you to be responsible. And we make you be responsible by putting it in writing. And that's memorialized in that manufacturer's agreement. Are they as big a company as you?
No, wouldn't think so, but they're probably not far off.
Okay, so you've got kind of equal status out there. Let's say that we've got, in fact, I'm going to give you a different example. I want to get away from using you specifically, but I wanted you to think about that.
Well, if you like using us, we use workers also, temp workers too.
Okay.
And my twist on it is that was our option to use temporary workers.
Correct.
They could easily have been employees.
That's
so
right.
having got past that and said our employee hurt somebody, it isn't any different than it had it been a temporary employee that hurt somebody.
And you know what? That is fine, because what you've done with that, I'm going to put it in my context, not Darla's context, mine. You've accepted that risk, right? You have no control over the hiring of that party, right? You haven't trained them, you don't know who they are, nothing about it, but you've accepted that risk as if it is your own.
Well, except that we would have, and that's where the agency comes in and says you trained them, you chose which one you wanted, you trained them, you put them into service.
That's right. And so you come right back to the agency and say, you got to be responsible, right?
Okay.
Okay. So let me give you a different example. This is a client. We're going to say that they manufacture electronic appliances, okay? And they have a contract with one of the big box stores out there. So we could say it's, I don't know, Sam's Club or Costco or pick one. I don't care. One of the big box clubs. Part of the wiring that goes into this appliance is manufactured in China. So we have a sub-manufacturer. They ship the wiring harness over here. We put it into our electrical appliance, and it's sold through one of the big box store chains. The contracts that we enter into with those big box store chains, they have a lot of horsepower because they're big box store chains. They're Costco, they're Sam's Club, they're Walmart, they're whatever. And they have a lot of power to dictate the terms of that agreement. So last year, the insured gets a phone call, the client gets a phone call, and they say, we've got a problem. We've had 4 or 5 of these appliances now returned to us because of fire. That in the back of the appliance, all of a sudden we've got a fire erupting and we've had damage. Okay, here's the problem. Because of the distribution agreement that, let's just say, Sam's Club has with them, Sam's Club has all the authority to do the following, which is exactly what they did. We're going to pull your product off of the shelves of all of our stores across the world. We are going to put it into a storage unit. We will bring inspectors in. We will inspect the wiring harness. We will find out if that's really what the problem is, and we will send you a bill. The manufacturer says, wait a minute. We want our inspectors to come in. We want to control this. We'll bring it off the shore. We'll send our trucks around, we'll pick up our product, we'll bring it back, we'll do all of it ourselves, right? Why do you think the client wanted to do that, to do their own inspection work? Why do you think, Talia? Instead of having Sam's Club do it, they wanted to do it themselves. Why?
Well, it's probably their own product more, and I understand how it's actually working.
Yes, right? And they could probably do it less expensively. They have an incentive to keep the cost down, right? And so what do you think Sam's Club said to that? No, thank you. We have the right in our contract to do that with you. Nobody ever read that part of the fine print. Nobody. The last bill that I've seen come through on this, we're at $2.7 million and counting. That is what has cost this insurance. Okay? That was a risk that was retained, that had not been identified, that had not been discussed, that had not been overviewed, that had not been anything. Nothing. Nothing. It was kind of like, Brian, I'll tell you what I call this. It's retaining risk under the wishing and hoping method. Does that make sense to you? I'm wishing and hoping that nothing ever happens like this, ever, because this client actually may not survive. Now, once that first phone call was made to them and they had their marching orders given to them by Sam's Club, and I'll tell you, I've changed this loss as much as I possibly can, so I don't think anybody can identify who it is, but this happens every day. What do you think the next phone call was? When that client got that call from the big box store risk manager who said, this is about to be your life, right, with us. What do you think that next phone call was that that client made?
To me,
Yep. To the insurance broker. Why?
tell me how I'm covered.
That was exactly what happened. The answer is, there is no insurance for this. Now, this was one of those areas that's where, because this client had actually been a client of this broker for 25 years. Brian, if I'm your insurance person for 25 years, I know you pretty well, right?
I would hope so.
I hope so. I hope so. And every year I have sat across this desk from you and said, Brian, product recall should be in your future, right? You are bringing components in from China. You don't have inspectors that are going over there and monitoring it. In other words, you've got risk that we can't control. Product recall insurance, buddy. And the answer every year was, no, thank you.
Takes too long to fill out the form.
Right. The damn form is too long
make a
and
good
it's too
product.
expensive, right?
Yep.
It's too expensive. That's what we heard over and over and over again. Here's why. In the world of risk management, okay, we look at a fait accompli. And what that means is if there is a loss under that coverage, it's a total loss. It's never a partial loss. Ever. So whatever dollars are purchased for limit, that limit will get paid. So it's either a 0 loss ratio to the carrier or it's a 100% loss ratio to carrier. Does that kind of make sense? Right? Okay. Yes, ma'am.
I did have, the client is not in this room. We talked about product recall. They put food out and sell it in it's in different components and places. And the client said, I don't need product recall. We have so many requirements by USDA
Right.
and all our inspectors and Costco and
yeah.
everyone else that we deal with. There is no way I won't be
Nothing's
able
getting
to.
past us.
Right, exactly. So, lo and behold, there's a product recall for a product that he may or may not have contributed to
Yeah.
the marketplace.
Yes.
And he said, if I had to go back and do it over, I would have filled out the form. So,
I had that with another
Yeah.
client, by the way. They were forced into a recall because of a different product that was being recalled, and theirs had to come off the market at the same time until they could test it. So, anyway, that was one small example, right? Assumption of risk can happen to us in many different ways, and it isn't just, I'll pay if somebody gets hurt on your property. It can be sometimes very complex and very difficult with a lot of other considerations. In that business contract, there may also well be a requirement to either have us added as additional insured to the other party's insurance for liability purposes, or vice versa. For example, if I lease this space in this building, the building owner is absolutely going to say to me, Marjorie, you will add me as an additional insured in the event somebody comes into this building, they trip and fall, they hurt themselves, and it's because they were coming to see you. So we want you to have your insurance take care of us. Have you guys ever gotten involved in adding other parties as additional insureds to anything that you know of?
I believe so.
Yes?
I believe so.
True.
Yes? 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 Joe, do you know? Yes? Absolutely. Right? Fatima, yes? I want you to all understand the one thing I really want you to take away from this. This is one of those moments now. It's not a criticism. It's information. You were not here for that part, okay? Because I don't mean this in a critical way. I just mean it as a factual situation. Steve, if I add you to my liability program, and I add you to my general liability insurance, my umbrella insurance, my whatever, I have given my insurance program to you. For free. For free. That is a very serious situation, and it's taken so lightly out there. But the thing I really want you to get from this, I'm handing my insurance to the other person. Here, you take it, you use it. You can have it. It's yours. Isn't it? Now, you like that, right? Why do you think Steve would like that? I'm going to hand him my insurance. Why do you think he'd be good with that?
He's not responsible any longer.
Yeah. And he didn't pay anything for it.
Yeah. I have a question.
Yes,
regarding that.
please.
If you're adding somebody's additional insurance for an event because it's required,
Could be.
that's not okay.
It could be an event.
Okay.
One of my clients has those on a regular basis.
Right.
Right. So here's what I've got. I've got now people coming to my client's property and they are putting on an event.
Mm-hmm.
We have caterers coming on site,
Mm-hmm.
right? We have beverage people, we have service people, we have trucks from all. They're coming to my client's property. All of them, every single one of them. I have said to them in a contract, you will not only indemnify my client, right, and pay all those costs, you will add us as an additional insured while you're here. You'll add us to your general liability, you're going to add us to your business auto, you're going to add us to your umbrella, and oh, by the way, in order for you to even get this contract, you have to carry $25 million of limits minimum, right? Minimum. How's that? You want this event that you're going to make a lot of money from, you will sign that agreement. And while you are there, your insurance is going to take care of me. Does that make sense? Your insurance is taking care of me. And I didn't pay you for that. Does that make sense? You're giving me your insurance. When you add a landlord as an additional insured, you are giving that landlord coverage for free. Does that make sense?
I wouldn't take that event. Not with a $25 million. No.
But that is a key issue because I think a lot of people say, okay, well we're just going to give it. Yeah, we're just going to give you this document, and it's a very serious situation, and it needs to be taken in exactly that concept of I just took somebody's insurance. Right. Yay! Yeah. Right?
And it's not over when the event's over.
No, it often isn't. Often. That is correct. That's right. It depends on the circumstances and what we're all doing with it. We have, Maria, for your company, you have as many different kinds of contracts as I can possibly imagine, right? Supplier contracts, transportation contracts, lease contracts, right? Equipment lease agreements, probably anything that I could dream up, you've probably got them. In some cases, you're being added as additional insured to other parties' insurance and vice versa, right? It kind of works in both directions. Exactly. So in some cases, you're saying, yay, we got somebody else's insurance, and in some cases, they're going, yay, we got their insurance. Everything is just peachy until something happens, right? And then the world looks at what did we do? What did we say? How did we express it in the contract? And who has to do what? And then all of a sudden it's really serious. We look at all the semicolons and the ands and the ors and the buts and the wherever for and how. We got to look at it in that same logical thought process before it's agreed to, not later. And a lot of times we're dealing cleanup later. Okay, so part of that, it's very challenging. So, each party that enters into a contract, each party can be responsible for their part that they assume in that contract. And we can portion it out, no problem. is the insurance designed correctly to cover as much risk as possible? I don't know. I have to first understand the risk. I have to analyze it, look at it, understand it, and then purchase insurance. But I'm going to tell you right now, when you just get a certificate from somebody, you have no idea what they really got. None. None. I'm going to go back to my client again. I just went through this with one of my clients on their renewal. This insured, my client, works with another company that could eat them for lunch and never even know it. And my client is tiny compared to this enormous company. They have a contract that both sets of lawyers had entered into 10 years ago. This contract will go out until 2032. So when I'm drooling in a nursing home, that contract is still going to be going on. So in 2032, they get to renegotiate terms. But in the meantime, we've got a contract. Everybody was really clear on exactly what had to happen, okay? And for the last 10 years, my client has been accepting a certificate of liability insurance, okay? And that certificate of liability insurance shows general liability insurance, certain limits of insurance. Business auto, certain limits of insurance. Umbrella, certain limits of insurance, etc. Well, unfortunately now the client has hired me. And I'm not a nice person. I might seem nice to you, but I'm really not a nice person. I come off nice, but I will wear you down. I'm like water on a stone over time because I will never, ever give up. You know what I mean? Mm-hmm. And I say please and thank you and all that, but I really mean it. Mm-hmm. So I got a hold of the risk manager that works for this really large client, the customer of my insured. And I said, thank you very much. I appreciate that you sent us a certificate of liability insurance. However, we need the supporting documents, and I gave them a list. And I gave them a little template. For this line of coverage, I need this. For this line of coverage, I need this. And I need this to show like this. And he wrote back and he said, I sent you the certificate. I said, well, it's just a piece of paper, though. I want to make sure that the actual insurance says what's on this little piece of paper, right? Because I don't care about that little piece of paper. I could care less about that stupid piece of paper. There are people that they love getting these certificates, like they have meaning. They're nothing. They're nothing. I could care less. So I wrote back to him again and I said, I need the following information, As mentioned in the last email, we need the following. Still really nice and smiley. And he sends me back the contract and says, show me in the contract where it says I have to do this. So I did. This was their contract. He is the risk manager for a global organization who has the audacity to send me the contract that I have quoted from in the beginning to say, show me. You know what that was called? That was rubbing my nose in it. He wanted to see if I was going to push. That's all it was. And I wrote him back and I said, I copied the pieces of the contract and I splattered it all over the email and I drew a little red arrow and I said, right here, right here, right here, right here, and I got my documents. That was 2 months of work. 2 months of work that I had to bill my client for that time to do. Do you understand? So why do people do this? Number one, because most people don't take this stuff seriously. Nobody cares until something happens. And had something happen, let me tell you something. The reason it took 2 months to complete is they didn't have the endorsements. Mm-hmm. That's why. And they had been in violation of that contract for 10 years. I only know that because the lawyer that works with my client called me and he said, I got a call from their lawyer. Mm-hmm. It's gone all the way up the food chain. What do you want us to do? And so we finally got it narrowed down where everybody could live with this, but they had been in noncompliance for 10 years. That is not acceptable in my book. And the reason it wasn't acceptable is my client was vulnerable to loss, that they didn't have to be. Does that make sense? Where they had agreed to it, and it's not going to be any other way. What I didn't want were 10 people dead before somebody figured it out. Seriously. Does that sound dramatic to you? It is kind of dramatic, isn't it? But that's the world of risk. We worry about what can happen, what can go wrong, and I want to make sure that my client is surrounded with protection as much as I possibly can before something happens. So reviewing the contract is critical. A lot of the clients that I work with, I get the contracts after they sign them. And I'm left sometimes with not such good stuff, you know? Okay, then you do the best you can, you know? You just kind of worry about it, but we have to think about what we're accepting and what we're rejecting. Here's the idea. If you are sued, does the other party have the ability to respond and take care of my client, right? Are they taking care of you? That's why I asked you if they're about the same size as you. So I want you to imagine for a minute, we're going to have another company that's going to perform a function for us, whatever that function is. And they're small. They're not a big company, they're small. And so we say to them, look, you need to carry certain kinds of liability insurance, you need to do this, you need to do that. And they give us that wonderful certificate, they even give us all the documents that we want, and lo and behold, something happens. Their liability insurance doesn't cover that claim. Because there's a whole lot of exclusions in those policies, believe me. And all of a sudden now that other company's liability insurance program says, bye-bye. We're not going to pay for a lawyer, we're not doing anything. It's not a covered loss. Here's why I put this here. If you are sued, does that other party have enough capital to actually pay your legal fees and pay the damages that that other party is going to sue for without insurance being there at all? And the chances are good that you're not going to know the answer to that. It could be a really large sub-manufacturer, same size as you. You don't know their capital, right? You know they can take the job and do the job for you, you hope, but you don't know their capital, do you? Nope. Okay. You'll never know that from a landlord's perspective or a tenant's perspective or anything else. So it's kind of a crapshoot. Seriously. So the biggest thing that we've got is the other party's insurance. So, insurance, when we talk about general liability or auto liability, any form of liability insurance, pollution liability, employment practices liability, all of it, the word liability means we're going to only respond when there is legal liability imposed upon the insured. So, Brian, when you guys buy that insurance policy, right, you sign your name on that premium and all that other jazz, if you're sued, somebody has to show that you're legally liable, right, for the court to order you to pay. Okay, how we get to that point can take months or years, but here's the point. Liability policies respond when you incur legal liability. That's where it has to begin. What is legal liability? It is a responsibility that one party has to another that can be enforced in a court of some kind. Whether it goes through mediation or arbitration or an actual court case is irrelevant. It is enforceable in court. Legal liability can be imposed in a lot of different ways. They can be imposed by common law. Common law is what is created and developed in our country over time. It is decisions that have been made by juries, by judges, by people that have taken a look at a set of circumstances and said, you know, we think it should be X, you know, whatever that decision is. You were drunk, you were driving, somebody got hurt, you should pay, right? That is a common law decision. Then the next area that we have is by statute. Oh, you were driving drunk? We got a law that's going to hurt you too. And we can have laws that say, if you are held responsible for X, then you must pay. Some of those laws might, for example, be in the world of pollution. There are a lot of laws out there on the world of pollution. It might be in the world of, gee, somebody's claiming that they were discriminated against, you know, at their job. So we have a law for you on that one. It could be assumed by a legal contract. Responsibility is assumed in that contract. And the contract doesn't have to be in writing. It can also be oral, although that's probably not smart. So, most legal liability is imposed by what's called a tort. A tort is a civil wrong. Not a criminal wrong, right? Not contract law, but civil. It's what happens in the world of society. I go out, I drive my car drunk, and I don't hit anybody. I violated the law, and as long as I've not gotten caught, I'm good, right? But if I drive drunk and I hit somebody, that other party can say, you caused me harm. right? You caused me harm in a lot of different ways, but the harm you caused was to me, personally, not just to society. The criminal codes are going to deal with you from a society standpoint. You caused harm to me personally, and I'm going to sue you for it. That's a tort. That's all that refers to. So most commonly arises out of unintentional negligence where I didn't really need to do it. It can arise out of something called strict or absolute liability. Let me give you some examples on this in just a few minutes, all right? So there's different levels of responsibility. For example, you guys make a product. That product goes out there. If that product hurts somebody, that falls under what we call strict liability. Maria, your company as well. Your company puts out a lot of products, makes them some cases, sells them in others without making them. But under all cases, it's held under a standard of strict liability, not just negligence. It's a very low bar, very, very low test of what can happen and what we can hold you responsible for. It can arise out of an intentional tort. An intentional tort example might be something like slander. I talk very badly about your company, and as a result, you lose money. Okay, that's under the law. That's called an intentional tort, based on violation of statute or common law, and then damages are assigned. And the damages are equivalent to whatever a court, a jury, a judge, a mediator, an arbitrator says you have to be compensated X number of dollars for what happened to you. Pretty simple. Now, from a negligence standpoint, here's where it starts. Negligence says, I'm sorry, your first name is?
Diana.
Diana. Mm-hmm. Diana, I'm Marjorie. Very nice to meet you. Diana, if I hurt you and you sue me, here's what you're going to be asking the court to say. Look at what Marjorie did to me. Make a decision whether or not she acted prudently, right? Did I do the right thing that a normal, common sense thinking person would do in those circumstances? And, Your Honor, if you find that she acted not correctly, not prudently, then you want money. That's all that is. That's negligence. I got in my car. I had had too much to drink. I'm driving down the road. I hit you and I hurt you. Okay? Is that a prudent thing to do? No! Okay? And I hurt Diana as a result of my imprudent behavior. I owe you money. That's it. Damages are what's assigned in our society to compensate you for the harm that I did to you, right? If I severely hurt you and you never ever worked again, do you think the amount of money is going to go up?
Yes.
Many clients, I've been in insurance business in some capacity for 39 years, which is an embarrassing thing to say, let me tell you. For 39 years, I've had clients, and they're no different today, say to me, how much liability insurance should I carry? How the hell should I know? I have said that to so many people, and here's why. Diana, I'm going to turn you into a 45-year-old neurosurgeon, okay? And we're going to have a car accident, and I'm going to damage your smallest finger in your right hand, and you are a right-handed surgeon. What's that claim worth? Millions and millions and I mean, I've taken away your livelihood that you studied for what, 14 years of college, right, and specialty training, and it's gone now. And that was an accident that was minor. Does that make sense? Okay, you tell me if you're going to hit Diana tomorrow, and I'll tell you how much liability insurance you carry. How's that? Okay? Because that's all I know. So understanding the world of liability and damages is horrendously difficult to do. It'd actually be better if I just killed you outright. Do you know that?
Yeah.
I know. You seem like such a nice lady. I don't want to do that to you, but really, seriously, it would be about the same. So when we think about negligence, this is the most common lawsuit that we can possibly ever have, okay? Property owner has uneven pavement in the parking lot and somebody trips and falls. That was me. I'm walking in for dinner one night, and people had put in beautiful new sidewalk around the pavement area. The cement contractor, when he left, he didn't smooth out that one last, bit of cement that had been poured, and he left those globs of cement, and my toe hit it. Down I go, because I'm a klutz. But I wouldn't have fallen had he not left that there to trip on. Can I go sue the contractor? Sure. I don't want to do that. I'm suing the property owner that hired the contractor. I'm going to let the property owner worry about suing the contractor. Do you understand? So, all right, that's pure negligence. Intentional act, a wrong committed by a party whose acts are performed with intent to cause harm to others, such as libel or slander. Strict liability. This one, most of you here. Strict liability is the world of product liability. My client that has the electrical appliances, that's got the harness in the back that's causing the fire, it doesn't matter if somebody made it correctly or not. It matters that it exists, period. If it exists and it caused harm to somebody else, you're going to pay that claim, period. This is a difficult concept for people to get, so I'm going to give you a really quick example, all right, because I think most of you are going to remember this example. A number of years ago, this lady by the name of Stella Lubrick became famous. You may not remember her name, but I think you're going to remember what happened. Stella, who was a lady in her late 70s, went through the drive-through window at McDonald's.
Getting tapas.
I knew she would do that. So she now goes through the drive-through window in Albuquerque, New Mexico, with her son driving the car. She's in the passenger seat. They get their, coffee for the little morning commute that they were about to take. They go over and they park the car. Right? Stella has got to add some cream and some sugar to her coffee, so she takes the lid off. How many times have you done that in your car, by the way? Huh? Tell the truth. Tell the truth. Okay? So she takes the lid off, okay? And she is going to put the cream and the sugar in her coffee. And in doing so, the coffee spills in her lap. Now, this is a 78-year-old woman. It's a little difficult to hop up off your seat when you're 78 years old and get out of the way of all this mess that's running in your lap now. Now, here's what the media did to this woman. The media pointed the finger at her in all these articles for months. How stupid our tort system had become in our country. Everybody's just out for what they can get. And they made her the poster child for how bad our legal system is. Instead, it taught me a lesson, again, that I know very, very well, and that is you cannot believe 1/10 of what you read, because it's either a lie or you're not hearing the real truth, or you're not hearing the whole story. Because here's what really happened to Stella. What really happened to Stella was, and all the news reports said, oh my gosh, when she won her case, she won $3.2 million from McDonald's. And everybody said, for what? Because she was an idiot? Because she took a lid off, she spilled coffee in her lap, and for that we give this woman $3.2 million. Are you serious? Okay, here's what really happened. When you go to drink your coffee, right? I got my coffee downstairs. That was the first thing I did when I got here this morning was I got my coffee, right? How hot do you think that coffee was?
140 to 150 degrees.
You hope. You hope, right? Now it's gone in that thermos unit and it's been sitting there for probably an hour, so it's probably down to about 110 degrees. You get your coffee out in the morning at home, unless you got one of those fancy schmancy little espresso machines, you're looking at about 120 degrees. This McDonald's was serving their coffee at 186 degrees Fahrenheit. Yeah, I want you to take coffee, and I would like you to just pour that coffee down your throat at 186 degrees Fahrenheit. What do you think that would do to you? Because let me tell you what it did to Miss Stella. She had third-degree burns to the bone. She had to have reconstructive surgery, none of which was talked about by the media at all. They also never ever reported the fact that Miss Stella said she never actually went to the lawyer in the beginning. She said, my Medicare's not covering all the reconstructive plastic surgery I have to have because I bought the coffee at 186 degrees Fahrenheit. That wasn't really what I was expecting. Could you help me pay for part of my Medicare expenses that they're not covering? Nobody ever reported that, did they? That was Miss Stella. They also didn't report the fact, and this is going to be important in another page, okay? They also didn't report the fact that they reduced Miss Stella's award to about $360,000. The reason the court reduced her award is something that's coming up. The court said, but for your action, Miss Stella, of taking the lid off imprudently, the injury could not have happened. However, McDonald's is not off scot-free because the owner absolutely knew that they were serving the coffee at much higher a temperature than was normal. They had been warned about it repetitively by corporate McDonald's. They had ignored it. That lawsuit then doesn't fall under negligence against McDonald's. It falls under strict liability. Strict liability says you made the product, the coffee, you served the product, it caused harm, it's over. It's paid. Do you understand? It's paid. It doesn't matter if you meant to do it. It doesn't matter about anything. It just matters you made the product, it caused harm, therefore we pay. There is no negligence requirement at all. Does that make sense? So even though we did have it at McDonald's standpoint, the negligence as well, doesn't matter. They would have been on it anyway. That was the other piece. The media did a big disservice to the public and didn't educate at all. It's made her the cause celeb of that particular month. I was involved with that claim. I saw what Miss Stella went through. It offended me greatly, you know, with all those discussions and all those things that were being put out there in the media very incorrectly. Any product that goes out the door of your company, you're responsible for. That's it. That's what strict liability is. And as a result, it means your liability policy is going to get very expensive, right? That's partly why. So, absolute liability, this is limited to very specific areas. Do you remember the lady that was keeping the gorilla when she like raised this chimpanzee, was it a chimpanzee, right? And she lost her face. Remember that? Okay. Remember that shit? It took her face off. It was horrible. Okay, had that been her friend coming to visit, you know, Mr. Chimpanzee, it doesn't matter what happened. Keeping wild animals means you are absolutely liable, period, for anything that happens as a result of their action. Doesn't matter if you've got them in a cage, it doesn't matter if you have them controlled, it doesn't matter, it doesn't matter, it doesn't matter. Blah, blah, blah. Write a check. Res ipsa loquitur. The thing speaks for itself. You're a construction company that does demolition work. You clear the whole area, 5 miles around that building, everything's cleared out of the way. One erroneous flight of a timber of lumber hurts somebody, you'll pay. Totally. Right? Absolute liability. Yes, ma'am.
Now, a woman visited her friend
Yes.
who happened to have a chimpanzee who did take off part of one arm, part of one leg, and most of her face.
That's right.
And she is now suing the state of Florida
Yay.
because the state of Florida should have told her friend that she shouldn't have had the chimpanzee in the house.
Many, many states allow keeping wild animals. And what she's doing is challenging the state statute and saying, you messed up to the state. It doesn't make the state absolutely liable, but it still makes that homeowner absolutely liable. Right?
Did she sue the friend?
She did, but the friend didn't have any homeowner
Right.
insurance. So now she's looking for somewhere to offset,
That's right.
and the state of Florida said,
Hello?
yeah,
What?
forget about it.
Forget it. So you get this push-pull all the time about people trying to challenge, you know, and do legal challenges against certain areas to try to get new law or break new ground or whatever. I haven't, that case is still going on, isn't it? I haven't heard a resolution to the state.
No, it's still going on. I read about it last week.
Yeah, yeah. All right, so now, one of the things I just mentioned to you, this whole issue of they reduced Stella's award, right, from the 3.2 to the 3, okay, here's why. In any situation, we have responsible parties. We have Miss Stella herself, who contributed to her own injury. We have McDonald's, who contributed to her injury. We also have the clothing that she was wearing that happened to be a jogging suit that held the heat in, you know? So that contributed as well. I know, isn't that something? Probably not at the right moment. So, any or all parties can be held jointly responsible for causing injury or damage to somebody else. We have also each party individually and independently of each other can also be held responsible for their portion. Now, here's where it gets a little weird. The world of joint and several, and this is California, by the way, Not all states are called joint and several states. Every state, California, Nevada, Oregon, Washington, every single state has its own statutory language that says this is what has to happen in an event that something goes wrong. You created a product, you are responsible for that product. You have a component manufacturer, they are responsible for that product as well, right? So you share that responsibility. In California, here's what it says. We have a liability statute in our state that says, Steve, your company did not manufacture the entire product. The company that manufactured the component part is actually responsible. Now, you use that component part, so we're going to say, hypothetically, that sub-manufacturer is 99% responsible for the injury, okay? Steve's company is 1% responsible, okay? That is severally liable, right? 99% and 1%. Jointly liable, both manufacturers are responsible to pay 100% of that loss. So far, so good?
Mm-hmm.
Make sense? Here's what joint and several. Steve, you're the only one with any money, you get to pay 100%. So even though Steve was only 1% at fault, our statute says you will pay 100% of that claim. When you hire people that are smaller than you, in size, in scope, in insurance coverages, it doesn't matter. At the end of that day, if they don't have enough money to pay those damages and you do, you will pay, period. One of my clients I mentioned to you is a very big property owner. They have many clients that are very big. And we like those really big clients because they've got a lot of money behind them. And they also have a ton of people that rent from them that are very, very small. If that injury happens in that very small tenant's location, my client's the big dog in that room, not the tenant. Do you understand? So I can say to that tenant all day long, you will pay. You will protect us. You will defend us. You will have your insurance come to our rescue. But we're the ones over here with $100 million worth of exposure, not the tenant. Do you understand? The tenant's out of business. So this constant situation of who did it, what happened, how did it happen, who's responsible, it all comes down to, Steve, you got the bucks, you're going to pay.
We have a strategy to make sure we are the lowest carrying insurance company out there, so that they always go after the other big guy
First?
first.
And you hope that works?
It's working so far. No, but
Carl, really?
When I sell you excess liability or umbrella coverage, because there is a difference,
Yes.
you will see that I will quote you what you want. I will also quote you more. I will also put a little caveat under there that says more is available. So it's up to you.
Right.
But the question I always get is,
How much?
how much should we buy?
I don't know.
Tony works for a company where we have many different certificates that we send, depending upon the contract that someone has signed. Someone might require 1, 2, 3, 4, 5.
Right.
Other clients of mine might have $100 million worth
Right.
of liability, but the contract only requires
Right.
3. We
That's
only
right.
show 3.
Right.
So the biggest exposure, I think, on an everyday, daily basis is got trucks.
Right.
So
Got trucks, got drivers, got loads. Right? Got wheels, got big lug nuts. You know, people actually try to challenge other people with more lug nuts than them. It never works well. Ever. It's true. All right? How much is the age-old question? I hope your strategy works. Because I'll tell you the other misconception that a lot of people have, and I'm not saying this with you, I'm just saying in general, I don't care about your insurance. I don't sue your insurance. If you hurt me, I am suing you. I'm suing you for my worth, not your worth. I don't care what you're worth, Melina. I don't care. I will sue you and I will get a judgment. I'm that 45-year-old neurosurgeon that just lost her pinky, right? I don't care if you have $1 million of coverage. I could care less. Your name is on that subpoena. not your insurance company. I will collect my damages against you. How long do you have to pay me my damages, do you think, Melina? How long? Immediately? I want them immediately. Do you have to pay them to me immediately?
Yes.
Well, what if you don't have the money? Now what? Now what? You don't have the money. Do you know that many states do not allow you to do that? California happens to be one that will, unless you do it so overtly the court can't ignore it. You will have to file bankruptcy as a company. Period. Get away from me. As I can collect on that suit permanently. It is called an unsatisfied judgment. It stays open in our civil courts until I am dead, and I can assign my rights of collection to somebody else. So I don't really care about your insurance. That's for you to worry about. I care about my damages, what I am worth. Okay? So when we analyze risk from a liability standpoint, it's not what you're worth. It's what you're doing that could affect somebody else, right? Mm-hmm. And what that other person, we look at their situation, and I'm telling you, it's tough. When you all make decisions, and I'm going to bring this down to personal, okay? You make a decision to buy auto insurance every year, don't you? Okay. The state says you have to carry $15,000 per person, $30,000 per accident, with a $5,000 maximum on property damage. How many cars out there are worth more than $5,000? Okay, I'm just telling you, okay? That's not a good way to buy insurance. I want you to instead look at how much do you drive? How often are you on the road? Are you on the road at key peak hours of traffic where there's a lot of idiots out there, right? Yeah. You're driving a long distance. You drive 2 blocks to work. It's a big risk differential than driving 20 miles to work. Does that make sense? Right, that's it. And then you look at what can happen. You guys have been really patient with me. Thank you. Would you like to take a little break? I think we need to get up and stretch and, right, get a little coffee, refill, get a little water, and...
Yeah.
Yeah? Get off all
Yeah.
that. Yes?
I would be negligent if I didn't tell you your lid's not on, because I don't want that spilled.
Oh, I know. It isn't. And thank you for my risk management. Actually, I don't care because it's Kyle's computer.
Early.
Oh, do you know
Yeah, you getting up?
but I
Get
knew
some
it
water.
was her. Carol?
Carol.
Carol and Darla. And Darla,
Yeah.
Darlene.
Yeah.
And see, she was really good at
I don't mind. I'm a lot calmer. I'm fine.
Marjorie loves
So the real question is how many messages?
Are you enjoying it?
Oh, yes. It's very interesting. I was just felt bad I was late. All that traffic.
Oh, it's all.
We get certain conversations when we think the mic.
Yeah,
is right.
exactly. Maybe some exposure there.
What we discussed here.
You're on slide 15, I think.
Bring yourself down.
It didn't open correctly, did it?
You know what? I think I need to sue Mission.
Yeah.
Taco.
I agree.
How could I not use their product without getting hurt?
I understand. I think they're seeing...
I go on the defense. How many
That's his
That's my, yeah, 3.5. That's where you were,
That's right,
right?
that's right.
Who trained you? Sue her.
Yeah, sue her. Oh, sue what? Sue her. All right, everybody, let's go. Let's get back to work.
No break.
Just a little break. All right, so now we've talked a lot at this point about transferring risk. Transferring risk either to insurance or transferring risk within the contract itself. So hiring contracts, lease contracts, installation contracts, manufacturing contracts, selling contracts, whatever it happens to be. Anytime we talk about transferring risk in a contract, we're not referring to insurance. In this context, we're saying, look, we're talking about the indemnity agreement that is found within the contract itself, where one party agrees to protect the other party, okay? The agreements will always, 100% of the time, be broader than the insurance that is purchased by either party to support those agreements. 100% of the time. The only way that you would ever have an indemnity agreement that is not broader than the insurance is if we said, Steve, I will agree to hold you harmless, indemnify you, and protect you, but only to the extent I actually have insurance for it. And you would probably never sign that agreement, because that's not what he wants, okay? So I'm agreeing to protect anything that happens, not just what I have insurance for. And that's the piece I wanted you guys to remember, all right? So as part of the business contracts, one party agrees to take care of all of these other expenses. The investigation of the claim, the court expenses, the defense costs, the damages to that third party. The party that is actually paying for all of this, there is a term for this person. They are called the payor, P-A-Y-O-R, indemnitor, right? The indemnitor pays the costs. The indemnity, with two E's on the end, is the person being protected. Right, okay? Person being protected. So we have the indemnitor, the indemnity being protected. The indemnity provisions is what makes all that happen, right? So O-R, payor, E-E, protecting party. The Y on the end is simply the provision in the contract that says that. So the indemnity portion in that contract describes the circumstances under which the indemnitor agrees to take care of the other party, who is the indemnity. All right, now, in looking at what kind of indemnification, and we're not going to spend a huge amount of time on this, I just want a kind of a basic overview. Limited, intermediate, and broad. Here's all I mean by the difference between this. And I'm going to use landlord-tenant relationship, okay? I'm going to be the tenant, you're going to be the landlord. On a limited indemnity, I, the tenant, am going to protect you, the landlord, in the event you get sued, but I'm only paying those expenses if it's because of something that I did. So a visitor to the property trips over a display stand that I have out, you are named in the suit, you are being sued because they got injured because of something I did, okay? Intermediate. Intermediate indemnity says, Joe, you're suing. You're suing the tenant and the landlord, both, okay? I agree to protect landlord, you, for that lawsuit that Joe is bringing if it arises out of any reason other than something you, the landlord, did by yourself. If it was something you were responsible for, I'm not going to take care of it. But in any other circumstance, I'm there for you, okay? Broad form. Broad indemnity says, when Joe brings that suit, I take care of you, no matter who caused it. Now, if you are the landlord, which one do you want? Do you want a limited indemnity agreement from me, intermediate or broad? You choose. You are the landlord. You're responsible for the pavement in the parking lot. You haven't done a good job at maintaining that parking lot. There are holes everywhere. It's a mess. Loose gravel everywhere. You don't have any lights up. You're a terrible landlord, but I still pay my rent to you. Joe comes along and parks in your horrible parking lot. Joe gets out of his car, is walking into my space, and he trips in one of those potholes. Do you want me to pay for your lawyer? Remember, you are the landlord, right? This is your building. This is your parking lot. Do you want me to hire a lawyer for you? That's all I want you to tell me. Yes or no? No. No? Oh, you're so nice. Oh, my God. Okay, you're like the nicest person in this room. Did you notice you're the only one that said no? Talia, would you like me to pay for a lawyer for you? Why?
Well, it should be advantageous for me not to pay anything about later tax.
So you're not as nice as Paulina.
That's because Talia's company pays to sweep the parking lot.
There you go. Oh, okay, you got that one. That means in order for me, right, in order for me to protect you, we had to have signed a broad form of indemnity, okay, to respond the way you said, right? No, you're not going to expect me to hire a lawyer. Then you and I are going to enter into an intermediate at the worst, okay, for me. Why? Because this was caused not by anything I did. It was caused by what you did. Do you understand? So, limited means I pay for you only when it's my fault. Intermediate, I pay for you when it's anybody's fault, except solely your own. Broad form says we don't care whose fault it is. Marjorie pays. Okay? Landlords like broad form because they're making somebody else pay for it. Tenants would like what? Limited. We'd probably settle if we negotiate at all on some form of intermediate. At breaks, you guys were mentioning sometimes you get involved in having to do a little bit of installation work and you end up installing things like shower doors, and then there's water, and the homeowner 10 years later is saying, excuse me, I've got water damage, and we don't know why, but even though we forgot to shut the door, we're still going to blame it on your shower door. And all of the contractors working on that job, right, all those years later are all coming back and saying, okay, how much do you want? And there's a lot of reasons that this happens. First of all, depending on the state where that shower door was installed, and I'm just going to stick with California, you guys install a shower door. You made the shower door, you install the shower door. You know, both directions. I'm the homeowner. That shower door goes in my home almost 10 years ago. State of California, we have a latent defect statute, it's Civil Code 2782. And 2782 says that I have 10 years to come after you. Yay! For something I don't see. It's called a latent defect statute of repose. And in our state, that's a very, very long time. Right? Because underneath that floor, because I've got tile on my floor, I can't see that my entire floor is disintegrating until we have a big hole in it. And it's all because of your shower door. Okay? That's a long tail of liability. The general contractor that built my house, guess what? I'm going to start there. I sue the general. You know what the general's going to say? It's going to say, so Brian, come on. It's your fault. You take care of it. Does that make sense to you? And that's all because of the indemnity agreement that Brian's company signed as a subcontractor with that general contractor that built my home originally. And all of that goes back to that indemnity agreement that was signed almost 10 years ago. Do you find that shocking that these things can last for so long and have such serious implication for so many years? Because that's what this is all about. And it can hang around for a really, really long time. All right. Yeah. Did anybody understand? Yes, of course you may, certainly.
So most of the time, people would probably just drop it, right? They wouldn't say anything, or, I mean, isn't that the general human behavior that people don't think, oh yeah, it's from 10 years ago, and I think culturally, I can say that, I think we just kind of almost, you know, it's too far, you don't really know the reason, so you don't pursue something like that.
You know, Nancy, I will say that you're not wrong. You're not right, but you're not wrong either. I understood the reference from a cultural standpoint. Here's what can often happen. In the example that we gave with the shower door, there will be somebody in that development that was developed 10 years ago that's married to a lawyer, or as a lawyer as a brother-in-law, or as a son-in-law that's a lawyer, or a daughter-in-law, you know what I mean? And somebody's going to say, wait a minute, this house was built when? And, you know, it starts. And that's usually where it comes from, because somebody's going to go, gosh, I never thought about that. Oh, then we can blame somebody else and get money so we don't have to put it out of our own pocket. That's life today. That's how it is. You know, and then, go ahead, I'm sorry.
It gets even worse, because then they start talking to the neighbors.
Yes, exactly.
And then
That's
the
it.
next thing you know...
That's it. The whole neighborhood. Right, the entire development is now selling.
And what happens is that the homeowners only know about the builder.
Right.
And the builder has agreements with every subcontractor. So the fact that one home may have had a roof leak is going to draw us in.
That's right.
And every other subcontractor. And they're going to go to every house, and they might even have unspecified damages to be determined later.
That's
and
right.
through all the negotiation process, they come up with a number and say, we need $1,000 per home. The shower people are going to contribute $200. The
Right.
roofer's going to do this. Somebody else is going to do that. And we had, oh, come on, give me a break.
That's
We
right.
had nothing to do with the leaking roof.
Right.
And we're
Doesn't
all
matter.
pulled in.
That's right. That's right. That's exactly right. That's just the way it is. And that's the way it is specifically within construction. It's a different world, let me tell you. That has been my world for 39 of those years. I know it very, very well. And it is a very complex situation, and it's different in every state. You know, so what you have here in California wouldn't necessarily be what you have in Nevada or Oregon or Washington or Minnesota, anywhere. It's all a little bit different across the country. But we tend to approach it in the same way, kind of the scorched earth policy. Everybody kind of approaches it the same way as California because it's like the worst.
New York's not so
Pretty bad. Yeah, pretty bad. All right, so this is just an example of an indemnity agreement. So I wanted you to see this because so far I've talked to you about concepts. This is what it would look like in a contract. ABC. Oh, and by the way, this is an indemnity agreement one of my clients entered into. So all I did was take the names out and change them. ABC shall indemnify and hold harmless XYZ, inclusive of the entities as shown below, their affiliates, all of their respective officers, members, managers, directors, shareholders, and employees from and against any and all losses. Remember what I said? It won't be just limited to what you have insurance for. It's anything. Okay? Anything. Any and all losses, claims, damages, and liabilities, including all legal and defense expenses, which any such indemnified party may become subject to, arising out of or in connection with work performed by ABC for any death, personal injury, or property damage to the fullest extent permitted by law. Isn't it great? So just one tiny example. That's what it looks like. I have seen indemnity paragraphs that will go on for an entire page of a contract. It's whatever the lawyer decided was the appropriate thing to write. And some of that can get very convoluted, seriously. It's like the lawyers get paid by the word, you know, so they just dream up many, many words. Now, that's an indemnity agreement in a contract, but now we have the insurance. The insurance responds when legal liability is imposed, well, at whatever point that is. The loss has to actually be covered in the policy, right? Just because you assumed it by contract does not mean that we're just going to run to the rescue. It has to actually be something covered in the policy. So, it has to be something like a bodily injury or property damage. The loss cannot be excluded. If the loss is specifically excluded, then forget it. Like, for example, I'm going to give you a real situation. This is a nasty one. This particular insured is a property owner, and they have a lot of different tenants in their center. One of the tenants. Really?
Oh, no.
Really?
No.
Okay, where's Darla? Where's the leader?
No.
All right. Miss Carroll, would you find out if we are supposed to obey that little fire response?
Kyle, take charge.
Okay, Kyle, thank you. So we will calmly wait to find out what the answer is. We'll find out.
Somebody cut that wire.
That's what I was thinking. Somebody cut the wrong wire.
They usually come over and say we have to do that.
I think we should take them with
It's not on the tax. Good to go.
It's not a, okay. All right.
Yeah, everybody is. Thank you. I probably shouldn't take time to
Are you
pause.
using your computer?
Nobody wants a brownie, I'll take a brownie.
Everybody right home? You jump in the car like...
Thank you.
Cookies and brownies?
I know, in the morning.
Well, there's more food coming, but
I know, everybody's
Gentlemen.
hungry.
Nothing.
you know, and if we're stuck up here, this is, it's gonna be really.
Right?
They're going to be really proud of you.
Mayor
That's
Lomo,
right.
kind of area?
Oh, wow.
Yeah, we left this one at 6:30. Got here at 9:30.
I know it's calling your name. I see you.
How about you?
I'm sorry, we're gonna go ahead and back a bit because the building management hasn't told us otherwise.
Okay.
Okay.
Better safe than sorry, eh?
Yeah, now I'm thinking, I got it.
Better grab that cookie now.
Yes, now how do we evacuate? Are we gonna take the elevator or no?
No, stairwell.
I think we need to take stairs. This is gonna be a great recording.
I know, I read that note.
How do I do this?
Would it be, would I be liable in any way for holding the seminar? Could be, sir.
Absolutely.
And me too.
Absolutely.
Only if the coffee's too hot.
I don't know, what was your agreement that you signed for this space?
And did they ask you to hold them harmless, indemnify, and protect them, right?
This is an extension of the space that we leased from Santa Monica when we need a bigger spot. So it would probably fall somewhere under my lease.
Sure.
And I did sign
And we
it.
have no contract, so,
No, yeah.
actually we do.
Actually, yeah.
I have an overriding contract
Right.
with Signature
Right,
Group,
right,
right,
exactly.
right, and BSW is part of Signature Group, so yes. Where I am held harmless and indemnified by you. Darn.
Dang, I hate when that happens.
Okay, so, before all the excitement happened, we said, indemnity happens whether or not there is insurance, right? Insurance only happens when it's covered. So, 2 examples. Someone trips and falls at the premises, files suit for injury, your landlord requires you to indemnify them, and you now have to pay for the attorney and legal expenses. That is a covered loss in the general liability policy, since you have assumed responsibility by contract, and the loss is actually covered by the policy. The insurance responds to pay the defenses and the court expenses and the damages for that other party. Here's the problem, though. This goes against your loss ratio. This is money that is coming out of your liability policy. All the payment for all the attorneys under the indemnity provision is going to come out of your limit of liability that you purchased. You know, Darla, you were mentioning how clients have many different limits of liability. When you indemnify another party, those costs reduce the limit of insurance. So, I'm the tenant, you're the landlord, I'm paying for the lawyer for you, it's a covered loss under my insurance. My $1 million of coverage that sounds so much in the beginning starts going away because your lawyer costs are coming out of my limit. Okay? That's an important consideration. I want you to understand that. So under contractual liability, I have assumed that contractual responsibility for you by contract. The money coming out of my insurance policy is reducing my limit, and it's affecting your renewability, your loss ratio, and your premium. Period. I don't care if you had anything to do with it or not. That's just how it is. All right?
Question for you.
Yeah.
My company has slip-resistant floors, so we have outside contractors
Yes.
come in and put slip-resistant floors at the time.
You bet.
And this is all throughout the area, which is a wet environment also.
Sure.
So we supply the boots for them, safety boots, the safety shoes, and all that stuff for the floor. How are we still protected today?
It's a whole other company that's coming in to do this work.
Yes.
You give them the safety shoes to wear, right, in the wet environment so they don't slip, they don't fall, and the worst happens, they slip and fall anyway. Correct?
Mm-hmm.
That is an employee of another company. So far, so good?
Mm-hmm.
I just want to make sure that I've got the facts right, too.
Or
That
Joe, are you asking about?
We have both. We have temporary employees, we have our employees.
Oh, your own employees. Or I thought you were talking about somebody that's an employee of a different
We have
company.
general contractors constantly
Right.
working in our plant, so it's all three.
Right.
Outside general contractors, our temporary employees, plus our own
All right.
employees.
That's that's great. Okay. Let's deal with the simple one first. Okay? The employee is a direct hire by you. They are hurt on the job. That is covered under the statutory requirements in the state, so it's workers' compensation. All right? That's actually pretty simple. I can make it more complex, but that's the simple answer. On the temporary agency, you are actually not their direct employer. It is a temporary staffing situation. The professional employer organization supplies that employee to you to fulfill a temporary need, correct? Because maybe you have more work coming in at that time, whatever. So we have a temporary staffing agency. The temporary staffing agency is the general employer of that person. That is the party to whom they look for workers' comp again. However, with temporary employees, you can also be deemed to be their employer. So if that staffing company has allowed their workers' comp to lapse, you can be looked at what's called a special employer. So we have the general employer is the staffing company. You are the special employer that will actually stand behind that staffing company. Your workers' comp should still respond. If you didn't have workers' comp because all you used was temporary, then you'd be in trouble, right? You could be deemed to be an uninsured employer. So far we're just talking about workers' comp. When I deal with that temporary staffing company though, let's say that they do have workers' comp, okay? So now they're treated as the general employer of the person. The answer I'm about to give you is going to be the same as if I've got a subcontractor that's sending in their people to my property. Because what can happen now is their workers' comp carrier pays for their injury. That workers' comp carrier can come after you and say you didn't give them the right equipment, you didn't protect them correctly, it was really your fault, and that's why we're having to write a check out under the workers' comp coverage, right? So they're coming back after you saying it was a premises safety issue, not just a workers' comp. So we want you to pay us back, right? That same answer will happen if we hire the subcontractor person, right? We have a contractor, they're sending their people into us, they get hurt on the property, they go to their employer for workers' comp. Their employer can come after you. That other person that was injured can also come directly after you, right? So both parties. In the first case, how do you protect yourself against that? A couple of different ways. In the agreement that we sign with a temporary staffing company, we can have in here a piece of language that is added to this that says you will agree to waive any subrogation rights arising out of any loss or damage to our employees. Right? We agree to do that. We will not come after you. Step number two, because there's a second part to that. We have to have their workers' comp carrier agree to that. And that is called a waiver of subrogation endorsement. So two things. One, an agreement by contract. And number two, the waiver of subrogation endorsement. Okay?
What about the alternate employer endorsement?
I'm going to get to that. I'm not going to go there right now because that doesn't solve everything.
Okay.
You know, what I just said will actually solve most of it, right? It won't solve the issue of they didn't have insurance, right? The alternate employer. But I'll get to that. I'm getting it. Okay, so I'm going to come back to that. But to answer your specific question, that's the answer. When I hire a contractor to come in and they're sending their people in, or they're sending a subcontractor in, it doesn't matter. When I enter into those kind of work contracts, it is critical to have that kind of, you will not come to us for injury or damage to your own people, right, to your own employees, right, or to a subcontractor of yours, injury or damage on our premises, and you will also waive any subrogation rights that you have. Then the second piece will then say, and your insurance has to agree to this as well, okay? So it's a safer way to go. Believe me, I've just been through this again with my own clients, trying to rework some of those contracts. They did not have that language in there. So again, it's tough.
Now, what if
Yes,
contracts
sir.
are not signed?
What? Say it again.
What if contracts are not signed? I hire, Brian to come do it, there is no contract signed. That's another
I've had that
situation.
situation.
We
I'm
had
going
an
through it
oral
right
agreement.
now.
You mean there's no
It's a
contract?
moral agreement.
Oral, he told me.
It's an oral.
Oral.
I know.
But, you know,
Yeah.
that oral agreement, you're not going to stand there and say to each other, by the way, you know, we will hold each other harmless and indemnify each other and blah, 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 blah.
It's just not too hard.
Well, maybe Brian would, but that doesn't happen. So then you're sitting ducks, and then we're all scrambling, you know, when the lawsuits actually happen. Now you're talking about, are you protected? Can you protect yourself? Because we didn't do it by contract. We didn't have anything in place. That's the phone call you're going to make to Darla, right? Now here's the answer. The general liability insurance that you buy is going to be able to respond under certain circumstances. If that person is not your employee, right? If it's an employee, it goes to workers' comp. If that person, God, you are going to make me go there, aren't you? Okay. If it is a temporary staffing situation where you will be protected is by use of what Darla said, and that's the alternate employer endorsement. That is an endorsement that goes on the temporary staffing company's workers' compensation policy that says, look, if you come after us, we're going to agree to protect you as if you are also the employer directly. Number one, it proves that they do have workers' comp. but you will still want that waiver of subrogation endorsement. Okay? So that would be one way. If it's the other side, where it's a contractor sending their people onto our property, they're not our employee at all, that's going to be general liability insurance that would respond, because they're not our employee. Okay? That's why you have that. That's also why you would have the secondary layer of the umbrella coverage in there as
Let's go
well.
one step further. You said that you have an outside party who comes in and makes your floors slip resistant or slip proof even in a wet environment.
Mhm.
Yes.
So we have a subrogation issue, and you want to get a certificate of insurance naming an additional insured.
For what?
But, well, with respects to their the flooring.
Are you talking about our own? Oh, now you're switching
No,
on
I'm
me.
saying the other party, the other contractor who comes in and does the floors.
No, I understand that.
Yeah.
The other contractor comes in to do our floor.
Yeah.
Who are we talking about getting hurt and suing here?
Let's say that even one of their employees.
Okay, all right, different situation here. So now we have one of your employees, and they have gotten hurt, and the contention is what? That the anti-slip resistant stuff didn't work?
Correct.
Now what?
Or shoes.
Now what?
The workers' comp insurance might want to subrogate against the contractor
That did the work. So now I'm looking for the indemnity agreement, right? Step number one, what did the contractor indemnify us for? And what did they verify to us that they had insurance for? Right?
Obviously under contract.
Right. I'm going to come back to that when I get to the next level, which is additional insured, because we're only dealing right now with indemnity, right? So additional insured is something different. You okay with that?
Yeah.
All right. Two directions, huh? What they can do to us and what we can do to them. And how it responds is it can actually get very convoluted, seriously convoluted, you know, where it goes back and forth even against both parties. All right. Yes?
The example of the indemnity agreement, is that a standard one where it can be applied at any contract?
This example, this one, this actually came from a contract that my client entered into for a new piece of property that they were having built. I have seen, and the only reason I can tell you that is when we got here, in connection with work performed by that company. When we got down here, I knew it had to have come from a contract like that. I want to say this courteously, because I don't mean any disrespect. You said something actually very important, a standard indemnity agreement. There aren't any. There really isn't a standard indemnity agreement. There are as many different paragraphs as there are lawyers to write them. I have seen, actually this is a very short one. I chose deliberately to fit it on one page so you could see it. I will tell you though that having long indemnity agreements, in my view, isn't always beneficial. Sometimes the more words you use, the more limiting the language becomes. You know, it isn't always broadening it. And I see this sometimes written by lawyers who just can't resist putting another word in there. So, could there be a different indemnity agreement for a landlord-tenant relationship? Yes. Could there be a different indemnity agreement between staffing situations or leasing of equipment or leasing of autos? Or yes. So, the basics, how about if we do it this way? The basic words. Indemnify and hold harmless. Very standard words. I don't think that this part is standard. I see a lot of, especially older agreements that do not have this, where we've included all of the entities, all the subsidiary entities, all of the officers, members, managers, directors, shareholders, etc. That's relatively newer language.
Becoming more common.
Yeah, way more common.
Even more people involved.
Exactly.
And successors.
And its successors and
Yes.
defines. This one doesn't
Yes.
have that. Correct. Okay.
And anybody in
Now, this
Yes.
is pretty standard stuff. Any and all.
Just seems new in the US
Yes.
and all that.
Right? Any and all losses, claims, damages, liabilities, including now. This part is also not common. You won't see this in every indemnity agreement. In the newer ones, again, yes. Including all legal and defense expenses. That's right. And the reason that started to come into the language from the legal perspective is because of a change in the insurance perspective. And that happened back in 1996. It didn't filter out until about the 2000 decade and going forward. Well, here's what it means. In the liability insurance policies, we added a piece of language that said, you got to expressly assume the requirement for defense of some other party, like contract, in order for us to come in. So the lawyers started getting smart, and they started adding that wording in there, which any such indemnified party may become subject to arising out of connection with. All of that is different. So could you take pieces of that and use it in any kind of contract? Yes. You know, getting down to the specifics of arising out of that part of the premises that is leased, you know, to you would be a change in that piece of language for a landlord, right, to use with a tenant. So the concepts are the same, but the structure can be quite different, contract to contract. Did that specifically address what you were commenting on? Okay, all right.
Can I just?
You can, of course, you can do
only
anything you
because
want.
personal example is
Yes.
Not only the other party's employee, and you have to deal with subrogation,
Yes.
but you also have to deal with civil liability when that employee individually decides to sue you, as well as you can be responsible to OSHA for not having a safe.
Absolutely.
And it wasn't anything to do with you.
That's right. All of those pieces, by the way, will be addressed in other paragraphs in this contract. It can, I have seen, I've mentioned to you before that I've seen this indemnity language actually go on for an entire page. Sometimes an uninterrupted sentence filled with semicolons, you know, where it just goes on forever. A lot of times I will see an indemnity agreement in a property lease that is combined with an exculpatory clause, which is completely absurd and actually very confusing. So sometimes we can get ourselves in trouble when this gets convoluted. We start entering into the issues of OSHA, Cal-OSHA, federal compliance, as well as, you know, state compliance and all the other fines and penalties and all that whole harmless language as well. It can get very, very tied up. Something like this where it says to the fullest extent permitted by law, the law in this case for any death, personal injury, or property damage, that isn't dealing with at that point with statutory imposition for fines for failure to comply with Cal-OSHA, for example, right? So we'd have to have another paragraph. But I've seen them where they do, where it just balls it all up into one big fat mess. This is hard.
Well, there's contracts that have multiple indemnity agreements
Absolutely.
throughout the contract.
Absolutely. For different reasons.
Yeah.
And it's one of the more challenging areas is from an insurance perspective. I'm an old insurance person. I'm not a lawyer. Are you an attorney?
No,
Do
absolutely
you kind of feel like you are sometimes when you read some of these things, though?
Yeah, that's why I just get a pen and start lining
Yeah.
stuff out.
No. Okay? We feel the
Contract doesn't go very far.
same. I know. It's like, what are you talking about? Darla and I feel the same way. Carol has to read a lot of these contracts, and the problem is when we look at them, we're saying to ourselves, we're not lawyers. But you kind of have to understand a little bit about how the law works in general to make heads or tails out of any of it. The other problem, here's the other thing I really, and this is personal. This is not something Darla told me expressly she wanted me to go over. Of all the things that I can encourage you to do throughout the course of your life, I don't care if it's a personal or a commercial life, either way, you need an insurance person to help you. And that means give them the contract. Do not give them a page of the contract. Give them the contract. Because I can't make sense out of something I'm seeing a piece of. Does that make sense? You've got a 100-page contract. It's got stuff scattered all the way through it. Then you give me a page of it. What, are you kidding me? That's like giving me a piece of blue sky on a 1,000-piece jigsaw puzzle and expecting me to know where it goes. Do you know what I mean? I can't do it. And Darla, I know, will give you as many disclaimers as possible. I'm not a lawyer. I'm reviewing this for insurance. But even then, you still have to have the whole thing.
And sometimes you'll have your lawyer, and your lawyer might be looking at a contract and not thinking of insurance issues.
Yes.
And conversely,
Absolutely.
your CPA might look at it and have a whole different
That's
spin
right.
on it.
Billing, work orders, progress payments, everything. It's a very different perspective that we get. I've got something on that actually, and I'll share with you a little story on that one when I get to it. But All right, so we got trip and fall. It's covered, it's paid for, responded to. The next example I want to give you is where we've got a pollution spill. Pollution spill may not be exactly what you think it is. The world of the EPA has changed, exponentially changed. It has changed your life and you don't even know it because it hasn't intersected your life at this point. When I say the word pollution to you, give me something that comes to mind immediately. What do you think is pollution?
Diesel fuel in the freeway.
Perfect. Diesel fuel on a freeway. Does that make sense to you?
Mm-hmm.
Now, I'm going to walk into your market. I'm going to walk down 3 aisles, okay? And everything in those aisles are a pollutant. First aisle. I'm going down the milk aisle. The milk and the cheese and the butter. That's number 1 aisle. Number 2 aisle is going to be where all the bleaches and the cleaners and the cleansers and the detergents and all that stuff is. And the number 3 area is the deli section or the meat section. All of it. We don't think of those things as pollutants, do we? Okay. One of the worst cleanup that I saw in a little tiny business, not a big huge thing, little tiny business. I was going to teach a class actually up in Northern California with one of my clients. And I round the corner in the little deli that was there to service like Oracle, you know, they're in South San Francisco area. And they're there for the breakfast and lunch crowd, you know, to take care of all the office workers there. And in front of this little tiny lunch deli, it's just this little tiny place, are all these guys in the white suits and the breathing masks and all this other jazz. Somebody had broken in that night, and I guess they got mad because there was no money to steal, so they decided to vandalize the place. They sprayed bleach and ammonia and all the other cleaners they could find everywhere in that little deli. Everything from the walls out had to come out. Everything. The tables, the chairs, the booths, everything. The little case, certainly all the food, right? Every plate, dish, towel, everything. All of that was pollution. All of it. Now I'm going to give you the big claim. This is a multi-million-dollar claim. At Christmas time, do you guys get like catalogs of people wanting you to order stuff, you know, out of a catalog? Every year I get this catalog, and every year I ignore it. I get this catalog from Swiss Colony. Swiss Colony is the company that you can order platters of sausage and cheese and, right, all that stuff from. Send it to a relative you want to die and leave you money. That's true. Here, more cholesterol for you. They have a huge fulfillment site out of Madison, Wisconsin. It's just outside town. And that's where they fulfill all those Christmas orders that come in every single year. They had a fire at their warehouse. You burn up sausage, cheese, and a huge supply of government surplus butter, and you now have fat that is rolling out of that building, right? That is being driven out of that building by the very firemen that are out there to try to put out the fire. And as all that fat is now carried by the water and carried by the smoke up into the air, and now goes across, pick any direction you want from Madison, Wisconsin, you got a lake, right? Mm-hmm. And I got this black cloud filled with grease that is about to go over one of those lakes, and the minute that warm air meets the rising air from that lake, it discharges the grease as a film onto the lake. That was a $19 million pollution incident, you guys. Not arising from diesel fuel on the freeway, right, which is what I wanted somebody to tell me. I wanted you to hear it, because that is from sausage and cheese and butter, the same things that you sell. That is a pollution incident. And that was only the part that happened away from premises. Do you understand? None of that is covered, by the way, in your insurance. Okay? The cleanup on site with a little vandalism, that's a property issue. But that third-party liability, I don't care who you've gotten to hold you harmless and indemnify you for any of that nonsense. That's third-party pollution of a lake far away from your property. That is third-party liability. Nobody's insurance is going to pick that up. Nobody's. So you've gone from slip and fall covered premises to a pollution incident that is not going to be covered by anything other than, guess what? Pollution insurance.
And a number of commercial package policies,
Yeah.
now letting you buy that pollution endorsement.
Mhm. Yeah. But not for $19 million.
No.
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 Yeah, huge claim. That was a number of years ago. I love that. Can't you just see that? Did that visually do it for you? That was my point, okay?
Yeah, just think, you're the client, and your insurance broker comes and says, you got a sausage, meat and cheese.
I know.
What if it burns? What do you tell that insurance broker? What are you, nuts?
What are you, crazy? It's meat.
There's
No,
nothing
in our world, and in the world of the EPA, you guys, that's pollution. That's a problem. What are they telling us to get out? Okay. Now, everything that I've talked to you about at this point has been indemnity, contractual language, transferring of risk back and forth. The second stage of this is, I don't just want you to hold me harmless and indemnify me, I want you to insure me, right? This is the part I told you where I ask you to put me on your policy as additional insured, you're giving your insurance to me, right? That's much better. I like that. It's not just indemnification now. It's actual transfer of insurance. It's a very different animal. So, a person or organization other than the policyholder who becomes protected under the policy is an insured. All right, now, do you guys have parties that are added to your insurance as additional insured? Do you have that situation?
Mhm.
You do.
Yeah.
Yes.
Because we're a union, and so we have leaders, and so they would be covered under our policy.
Okay. Now, leaders, who
Of
do you
the
mean?
union.
Of the union. So
They're
these
elected-
are volunteers, elected, non-paid people.
Volunteers,
Okay.
right.
Normally in the policy, we give coverage for officers, directors, kind of automatically, right? So you have the policyholder who's listed, the union on the face sheet of the policy, but then we bring in the employees, the staff, the executive officers, etc., in as insureds on the policy as well. Are the leaders that you're talking about now, would they be more like volunteers? Okay. Volunteers, I can give status for them for coverage as well, right? So they're now another insured, okay? Understand, every single person that ends up having covered status under the insurance, it's the same limit of insurance, right? It all comes out of that same pot of money. If you are married with 12 children, you have a single limit on that auto policy that's going to take care of that auto accident. Do you understand? Whether you have one child or 12, right? You have one person insured or 30. Now I'm going to bring in an outside company. Do you guys have any people that you add to the insurance as additional insured?
Yes, retailers and
Okay, retailers.
builders.
Right. Okay, retailers and builders. You guys do as well, right? Landlords. A lot of landlords. Okay. I want you to imagine now the retailer, the vendor that's selling your product, right? They're on your policy as an insured. You got a landlord, right? They're now on your policy as an insured. Okay, here's what that really means, you guys. Yes, we have exclusions in the policy. Yes, it might take away the coverage. But here's the truth about what's really happening. The vendor that we add to your insurance, we treat them just like you. From the standpoint of the insurance, the defense, the indemnity, the payment of coverage, in other words, the insurance carrier makes no distinction between you, the client, that bought and paid for the insurance, or the landlord that never paid a dime for the insurance. We make no distinction. Each party gets exactly the same type of response of coverage in the policy. So when you enter into those lease agreements, landlord gets named on the policy as additional insured. Here's what we're saying. Share the limits with the landlord. Share the limits with your vendor, right? Everybody gets the same kind of defense, and we pay out, and we don't care who we pay out first for. So, I come to your property, I come to your store. I get hurt. I sue landlord, I sue you, right? Everybody says to your insurance company, take care of us, right? Marjorie's suing everybody. There's nothing, in fact, there's actually opposite language of this in the policy. Here's what the general liability policy is going to say. For Cardinus Market, we will respond, we will hire lawyers, we will defend you, we will pay on your behalf. they're also saying the same thing to the landlord. You got $1 million per occurrence of coverage. That's it, right? That's all you have. That's $1 million total for both, not for each. So landlord gets their dibs in first. The insurance carrier could, I'm not going to tell you this will happen, but I'm telling you here's what could happen. The insurance company could completely write a check on behalf of the landlord and ignore you completely. That's what that means. When I tell you we treat everybody the same on the insurance, it is the most equality you will ever see, ever. Because the language in the policy says we treat everybody as if they are the only one standing in front of us, with the exception of limits of insurance. So, Marjorie's really hurt, she sues, and her lawyers are not giving in. The insurance company could write a check for that $1 million on behalf of the landlord and forget you completely. That's what that means. So when I tell you, you hand your insurance policy to somebody else, that's exactly what I mean. It can leave you with nothing. And you're the one that paid for it. That's the important part of this. It's also why when you start layering on a lot of additional insurance onto the policy, to look at, do you have many vendors or just a few?
We have hundreds.
Since I don't know your business, I'm kind of playing a guessing game here. If something happened with your product and somebody claimed injury, could you be looking at a situation where more than one vendor would look to you to respond for them? I mean, could a suit involve more than one vendor?
Anything can happen, but typically it's a customer at a particular retail location. So
I guess I was going more toward, do you have an exposure for class action?
wouldn't think so.
I'm going to give you that status just for a little bit to make my point, okay? Well, no, because I'm thinking, okay, if I have a product that you've manufactured, and I go to a lawyer who's a little eager beaver, who then starts looking around to see if there have been any similar claims, any similar lawsuits filed in other jurisdictions, maybe could put out a notice and say, let's go after Steve. You know, he looks like a good target, and now we got multi-state, multi-vendors, multi-jurisdiction. Mass tort litigation, every litigator's dream. That's you. Okay? Now we've got multiple vendors that sell their product, all coming at them saying, defend us, take care of us, we're an additional insured on your insurance. You understand? And at that point, the higher the limits, the more successful your company's going to be at making sure you're still in the mix. And that's the truth. Because there will be a point, at some point, where those limits are going to go away. Right? If we actually have to write checks out to pay those damages.
Now, question, you talked about Danielle also going through the owners individually. How, and I'm playing devil's advocate. How impenetrable is the corporate veil?
Oh, it's not impenetrable at all.
But is it at all?
No. No. Not at all. Okay, and I'll address that really quickly. A lot of clients and a lot of lawyers will say, let's set up a corporation or let's set up an LLC so that we'll put a protective device between us, you know, and the suing public. Okay, keep those hordes of people away from us. Because we don't want our personal assets to be penetrated, right? We just want to have the corporate assets. I got to tell you, that is so not successful. Never. And I just want you to be aware of this. Now, I've already given you my disclaimer. I saw that look. I saw that eye roll. What? Now, here's why. Here's why I'm saying this. I formed an LLC myself for my own company, right? So Segale Consulting Services LLC, okay? Why did I do that? I did it for two reasons, taxation and protection of my assets, okay? I am the managing member of my company. Here's the problem with this whole theory of protection of personal assets. I perform a role outside that of just the owner of my company. I actively work in my company. So, let's say we have a corporation, You know that corporations are owned by stockholders, yes? Could you just be a stockholder? You just own stock. Done. Assets protected. Almost no liability to the public of any kind. Okay? Could you be a director of that corporation and sit on the board of directors and make the legal decisions for that company? Yes? You're no longer protected. In other words, the corporate structure and the LLC structure is designed to protect owners. It is not designed to protect officers and directors of that company or the managing member. Do you hear it? The member, yes, not the managing member. Okay? That's simply life in the big city. It is never shielded the personal assets of people that are actively working in the company, ever.
As a corporation also?
Yes. And I don't care if it's an S Corp, a C Corp, or a publicly traded corp. Nothing I said to you makes any difference. So if I am actively working in the company, are you an officer of your company? An executive officer? Are you a stockholder? Okay. As an active officer, your personal assets are at risk. Period. If you were purely an owner, right, and you were not active, you were just an investor, let's say, in the company, your assets are protected from that standpoint. It's a different connotation. The general liability policy automatically includes all executive officers, directors, stockholders, partners, members of an LLC, managers of an LLC, and employees. We automatically bring all parties in because we know you're vulnerable. We know you can be named personally. That's contrary to what you've been told, isn't it? Yeah, I know. But it's okay. I know I'm right, so you can check. No, and I don't mean that egotistically. I mean that I have spent my career finding out about this because it is actually a question I get asked a lot. Yes.
So on the LLC,
yes.
In your case,
yes.
You are the only stockholder.
I am actually 90% owner of the company.
Okay, so you have a shield then.
I have a 10%, but I have a shield as an owner in my role as an owner.
Right.
But I have another role. I'm here talking to you today. That protection does not extend to me when I'm actively working in the company.
So there should be another coverage for that.
Yeah, and I have it. That is called the type of directors and officers. But it also is my general liability insurance, right? For the bodily injury, the property damage. If somebody could say, and honestly, most litigants don't name the individual officers, or directors. They just don't. In a slip and fall situation, you're not going to see, Maria's name on that lawsuit. They could, but they don't. They typically go after the corporation.
So you mentioned
But we have coverage automatically for you in the GL, so you're automatically there.
So will you just address for just a minute or two the directors and officers coverage?
Sure.
And why you might need it even though you are not a publicly traded company with a big board?
Oh, okay, sure. Okay. As a company, believe me, I'm a little tiny company. I'm not publicly traded in any way. Little tiny company. I can be sued. And the pool of litigants out there are not stockholders. Let me start from a different direction. Publicly traded company, all right? Big, huge company. ExxonMobil. Their pool of litigants that can sue them for business practices are their stockholders. That's their biggest pool of litigants, are the people that own stock in ExxonMobil and say, you're running the company into the ground, and I didn't get my dividend, and I'm going to sue you. That's publicly traded corporations. Privately held corporations, including LLCs like mine, that's not the pool of litigants. It is customers, suppliers, vendors, competitors. That's it. That's your big four. A competitor. Restraint of trade, dude. Aggressive predatory pricing. You're coming into my marketplace, you're running me into the ground because you've come in and underpriced the market by 40%. You know you can't make a living at that. Your sole function for doing that is to drive me out of business. That is a D&O lawsuit that will be filed by a competitor. That is a covered loss under something that we call directors and officers liability. D&O coverage is for lawsuits involving business practices. And those suits get filed, usually, against the individuals that are running the company that made those decisions to do that, as well as the company itself.
But for some of the people in the room, that is very important to you.
I would say that's true.
So that doesn't, the DNO does not necessarily strictly for the owners of the business. It's directors, officers who manage the operations.
That's correct. That is specifically who it's for. So D&O coverage actually doesn't respond for stockholders because they're already protected by law, right? It's for the directors and officers of the company that are so personally vulnerable for every decision that they make in running the business. It's one of the few areas that actually is, you know when I started I was talking about enterprise risk management? It's one of the areas that where the D&O coverage is one of the few policies that actually kind of follows the concepts of enterprise risk management. ERM, look at the good and the bad, to move a company forward, to retract it, to buy a location, to not add a product line. It actually tracks a lot with your vulnerability in running the company from an enterprise risk management standpoint. It protects you. In the event somebody says, wait a minute, we think you made the wrong decision 3 years ago, and we're going to come back after you now personally. All the decisions that an executive officer or director or manager or managing member of an LLC, they're all vulnerable, as are partners of a partnership. Yeah? I know.
Good.
Sounds good, huh? So the pool of litigants becomes very different. To get back to your original point, it's not the stockholders that sue, it's everybody else. As a union, you know who your pool of litigants are? The members! Woohoo! Yes, of course. Okay. Oh yeah. Yeah, exactly. All right. Okay, so in thinking about who is an additional insured, we have to look at who's covered. It's two issues. One, what does the contract say about who has to be covered? And number two, what does the policy say about who is going to be covered? Is it the company only? You mentioned you have a lot of vendors, the retailers that sell your product. Is it the retailer by name, or is it include their officers, directors, partners, members, employees, etc.? So in other words, who are we responding for? Is it just that entity? In a landlord situation, is it just the landlord, or is it also their property manager? Where they might have a separate property management company. We've seen it all. The scope of coverage is required by contract versus what is the language on the additional insured endorsement itself. When does the coverage requirement end in the business contract? You guys were talking about the issues on installation.
Mm-hmm.
And in California, you know how it can go out there 10 years after you complete that entire project, not just when you do your work, but when the whole thing is done. A lot of the construction contracts that we see today, we know that tail exists. The law says, hey, the buyer of that property has a good 10 years to go after you, so we're going to require that you continue to carry insurance and keep us covered as additional insured for the next 10 years. Cool, huh? It happens all the time. If I sell a product of yours, I'm your retailer. How long do I want to be covered on your policy? Do I want to be covered on your policy just while I'm selling your product?
For as long as there's potential for liability.
Okay. How long could I have potential for liability from selling your product?
If you're in business trade, it's 10 years. Out on the market, retail, I don't know.
That's right. Could be years and years, couldn't it? Uh-huh. Okay, why? Because that product liability tail goes out there forever. When a customer buys a product from your store, that product could be a fresh product, correct? Mm-hmm. Its shelf life, how long is it? A day or two? Right? I take it home. How fast am I going to eat it? If it's fresh, it's going to be pretty quick, don't you think? So then your tail of liability is about, what, 2 days? A week? Right? Okay. Now what if I buy a canned good product from you? Now how long is it? A year or two? I've got canned goods that are older than me. Okay? I'm sure that somewhere in the back of my pantry is some canned good product that is older than me. Okay?
Uncle Ned started to.
Yeah, it's probably, bulging and, at least it's older than my son. So how long is the liability, right? When I open the can and I get sick, that's when I'm going to sue. So the tail of liability on preserved items, right, is much longer than it would be shelf life on fresh. Does that kind of make sense? That's what I'm talking about. So however long that future vision is, that's how long the other party should be listed as additional insured. And that would mean in reverse for you too. Right? If you got that sub-manufacturer, how long should you be listed as additional insured on their policy? I want it forever. Forever. Why? Because the tail of their product is long, really long. And the suit could come in 10 or 15 years in the future, and I may not even be around to deal with it, but I still want you covered as additional insured, right? Even if they're no longer manufacturing that product for you. Does that make sense? Because it goes back to when did somebody get hurt? When did damage actually happen? So there's a lot of different considerations here. When, how long, what does the contract say? And a lot of times that contract is worded very badly on some of these areas. Now, here's the other thing you need to be really aware of. Oh, yes, ma'am. Yes,
Say,
ma'am.
for example, we've looked at the issue when you mentioned vendors.
Yes.
We've kind of been changing things around because we used to just endorse all kinds of vendors, right? So now we have associated vendors who we have had for a long time, but we mentioned we're not financially, we haven't vetted them and blah, blah, blah. So, but say someone says, okay, I got a vendor maybe for a disability and health plan or whatever because they came to my school.
Right.
And the union had a letter saying that they had a relationship with them. Okay, 20 years later or whatever, I'm in this situation and they haven't given me what I deserve or they haven't given me my insurance coverage. How does that affect us?
You could be named in that suit.
I'm sorry?
You could be named in that suit. Clearly.
Okay. And so we could be sued for whatever the
Oh, yes.
situation is. Because even if we have words that we have not endorsed or
Now you went from could you be sued to imposition of legal liability.
okay.
Okay? I'm gonna use what Darla said earlier as an example. Every year you talk to your clients and every year you say, here's your liability quote, but you can buy more. Right?
Mm-hmm.
That's a disclaimer.
Mm-hmm.
Okay? Every year. Why? Because Darla knows if there's not enough, don't look to me. You could still look to her. You can still sue her, which is very bad risk management, but you could, right? Could you win? I don't know. Because you're going to have somebody like me stand up saying Darla did everything she could to tell you this is your choice, your decision. So you went from could you be sued to could you lose, right?
Yeah.
Your disclaimer is very necessary. Will it stop litigation? No. Can it defend you? Yes. Right? So we're back to what do you need from that vendor? You probably need a perpetuity indemnity agreement at the very least, right? In just period, that goes on ad infinitum. As long as it can be imposed by law, they're indemnifying you. Should you still be looking for additional insured? The problem is the circumstance you gave me is actually very difficult to comply with in insurance, in the real world of insurance. You went to somebody is coming to your members with an insurance product for them. In order for you to be correctly protected by them would mean that you would be listed as additional insured on their errors and omissions insurance. That's not going to happen. In real life, that's never going to happen. Okay? So you're back to the contractual indemnity as opposed to additional insured status. Are you okay with what I just said? Okay. Did that make sense? Okay. That's a tough one.
We're changing
Can I ask?
Absolutely.
Additional insured, we issue the additional insured, usually it's under threat, they'll withhold payments unless
Yeah.
we give them all that. So finally all the payments are over, the policy comes on to another year and say, I'm not worried about you withholding payments, but I'm not going to add you this year.
What does your contract say?
So the contract says that for whatever length of time is forever, I'm going to give them additional insured endorsements.
That's right.
But I choose not to.
Okay. Cool. Breach of contract. Yay!
So I guess my real question is, that the successor insurance company, because I change insurance companies every year,
Oh, yeah.
comes along and says, I don't know anything about additional insured endorsements, so you're on your own?
Mm-hmm. That's right. That's right. Yeah. One of the things that you brought up, which is so critical, just because you agreed to do it in a contract doesn't make it automatically happen in insurance. Ever. And that's a hard concept, you know, for a lot of people to accept. If I've agreed to do something in a contract, and then you expect that agreement to affect another contract, I guess what I want to say to all of you, we use the phrase insurance and insurance policy all the time. You actually need to think of it as a contract, because that's what it is. It's a written express contract. So you've got a contract over here with a vendor, and then you've got a separate contract over here with an insurance company. And what you put over here really doesn't affect anything over here. Do you understand? On the indemnification part, right, just take a step back. On the indemnity part, yes. And the reason is this contract of insurance over here says, if you agree to something over here in this contract, we're going to respond as long as it's something covered in the policy, right? So it's saying, it's agreeing to that. Here's what you don't have over here in this contract. If you agreed to provide additional insured status, we're going to give it to them automatically. Now there is an exception. I'm about to get to that. And that's this one. It's called a blanket additional insured. You can say to Darla, yeah, they're not selling for me anymore. I'm not going to give them any additional insured status. But what the carrier might have chosen to do, and this is that new carrier that you wanted to move to again that next year, they might use something called a blanket additional insured endorsement. A blanket additional insured endorsement is really to save the insurance company time and money. It's not to help you at all. It's to help them, because they don't want to mess with you all the time. The more they have to mess with you, the more money it costs them. So it helps them by saying, we're going to give automatically additional insured status when you have agreed to do so in a contract or agreement that is in writing. Does that help at all? Have you seen these things before? A blanket additional insured? Have you seen those endorsements before? Yes?
Yes.
Right. For example, a landlord, we might say, okay, ABC Leasing Company is hereby added as additional insured. The other way to do it is, okay, any leasing company is hereby covered as additional insured when required by written contract. They're automatically covered. So we're not listing ABC Leasing Company. You might have a blanket additional insured vendor's endorsement, you know, that says when required by written contract, boom, automatically insured.
And you'll know you have that because the certificate holder will call you back and say, but I want my name on it.
Please put my name on it. You don't need your name on it. Yes. Yes.
Yeah, they want their name and they want the
Oh,
ISO
please give us
form
a
and
name.
they
I
want
know, yes. Yes, wait a minute. We gave you better status. Never mind. We won't even go there. Okay. Oh, that's when you know they need a change in their insurance program. Okay. So, truly. So blanket additional insured is this automatic reaction. So, to change my answer to you, if you have that on that successor insurance company where you said, I don't care about those vendors anymore because I'm no longer selling through them, if you have this on there, they're protecting you against your worst instincts now. All right? So yes, then they would have status automatically. Did you have a follow-up question on that?
No, I mean, I avoid issuing additional insured certificates when they cost me on a per certificate basis. So I don't need them anymore. If it's going to cost me $500 to issue them an AI, and I don't use them, I'm not in a builder situation.
Yes.
It's all done, over with.
Right.
You're on your own as far as I'm concerned.
You know, one of the things that I would consider in that situation, are you guys actually getting charged every time you issue a certificate on these things?
No. Most insurance carriers will give you the blanket additional insured.
For a flat cost.
Right. Some will give you a blanket waiver of subrogation.
For a flat cost.
Some, some will give you automatic, and some will throw it in. Depends upon the negotiation. Depends upon the carrier and the filer.
But for the most part, you're not getting that kind of expense thrown at the client all the
No.
time.
Because quite frankly, even if an insurance carrier charges you $100 per certificate,
they don't want the paperwork.
No.
It costs them $250 to generate the paperwork. So they don't really want to be involved in that. So that is.
Well, we have, in the 10 years going back, we have carriers that are
Sure.
$300
Right.
to $500
Sure.
per certificate.
Absolutely, and especially in some of the ways that you used to do business, and in some of the ways that insurance carriers used to do business.
Right.
Insurance carriers they used to actually mail us policies.
Oh, God.
So they don't do that
The
anymore.
dinosaur
Yeah,
age,
but,
yes.
But insurance carriers
Right.
are trying to streamline their costs as well.
Right.
So sometimes you'll have a insurance carrier saying, we'll pick that up at audit. So you'll see that a little bit differently. Mainly you'll see.
I'll see those costs come in now where the other party does come back and say, I want it specifically. I want a specific additional insured endorsement. No, you have to name me. That's where I'm still seeing that. You're not? So much?
We see that. We see it from, you get the certificate clearing houses,
Yes.
like,
Don't get me started.
what's that one called?
They're a bunch of damn
Compliance
fools.
Depot, yes.
Yeah, but they should be called, we are damn fools and don't know it. Okay?
Yeah.
They're horrible.
Yes. Well, it's because they're not insurance people. Yeah, they're trying to do the job of somebody that doesn't understand. Best way to solve that kind of situation from occurring is to go to the blanket additional insured. Second mechanism to stop that, that $500 a pop thing, in the contract that you signed, you need to express the kind of additional insured endorsement that you will be providing.
I guess I need to know the kinds.
That's right. That's exactly right. That's why you need the broker, okay? Because the lawyer will not know. They simply will not know. You have a standard agreement, standard vendors agreement, standard language that says that. Where you're going to get in trouble is on the construction side, right, where the installation work has to go
Right.
on. That's where you'll start getting into trouble.
And that's why you need to train your people
Right.
on what the actual real cost is when you've just given away your insurance.
That's right.
Versus the cost
That's
of
it.
how much you're going to make off the job.
That's right. Vendors, transporters, haulers, landlords, subcontractors, sub-manufacturers, vendors agreements. All these people come clamoring at you to have your insurance come on board for them. You are giving your insurance to them. They are costing you money in some cases. That has to be allocated for. All right? Understanding the language that should go in the contract so that that doesn't happen incorrectly, where you can go to that other person and say, dude, I gave you what you agreed to in the contract, right, which is the blanket additional insured, not some specific CG 2026 or some stupid 2010 1185 that you're never getting again in your entire life, dude, and no, you haven't gotten that from other people because it's not available in the residential construction marketplace anymore and has not been since 1999. But, hey, I digress. Anyway, okay, so you got some phony agent out there that's copying some old endorsement out there, good for you. Commercial construction, you can still get it, but not on the residential side. So, when you're able to come back and say to them, this is what I agreed to do and this is exactly what you've got.
Okay.
That's the key to making that whole thing work. All right? Without that, you're dead. Right? If you just signed a contract where you said it, you are on the hook. Can you not send it to them? Great, but that's where your blanket additional insured is going to have to come in.
You're going to have to change the language on those contracts when you see.
I tell you, I'd line them out.
I bet you do. Get that old red pen going, baby. Right?
Blue.
Blue, whatever.
They go right out.
That's right. Gone. All right? From the standpoint of the additional insured, look, it's really all about getting access to somebody else's insurance. So I could talk about all the problems in the world, and nobody will care. All right? There are some tweaky little issues of difficulties that might be created for the additional insured. I guess the bottom line that I wanted you to know is you don't have a lot of horsepower now. You're using somebody else's insurance, right? You don't have a relationship with them. They've never heard of you before. Especially, you're on their insurance as additional insured. So if the shoe is on the other foot, right, and you're becoming additional insured on somebody else's insurance, they don't know you. You're a nobody. They'll defend you. They'll take care of you. But you're nothing special to them. And that's important to understand. I've had a lot of people in my career say, well, I'm additional insured on somebody else's insurance, so I don't need my own. What, are you kidding me? Okay, that's living dangerously. That's a very scary thing because that other company might not be there for you. You would like to think that they would be, and they might not. All right? The benefits of the additional insured is they get access to somebody's coverage other than their own. That's the point. From the policyholder standpoint, you're diluting your coverage. every single time that somebody else goes on your insurance, you are diluting your coverage potentially. You are looking at adding somebody that can give you an adverse effect on your renewability, on your loss ratio, on your experience modification, etc. This is a dangerous one as well. Some of you may have a deductible. We have, let's say, a liability deductible per occurrence, $10,000. You're not sued. The additional insured is sued. You're not sued. The landlord is sued. Who gets to pay that $10,000? The landlord or you? It's going to be you. You have to cost allocate for some of those things. In a property lease, that landlord often requires that insured status on the tenant's policy. The lease usually does not specify the kind of endorsement to be used. It's kind of an area that needs some work done on it for sure. Some landlords ask to be named on a lot of the tenant's policies, including business auto, maybe the garage liability. Sorry, dry throat. Occupational hazard. Sometimes that happens and I can't tell it's coming. Yeah, sorry. Okay, at any rate, a lot of contracts require A+ rated carriers. That goes to an AM Best rating, size, and supposed quality of the company. They might also want to be listed on the other client's insurance policies as well. General liability, business auto, truckers, auto, umbrella. Don't do workers' comp, it won't work. This is a GL endorsement. Excuse me. The general liability endorsement, here's what it says. Who is an insured? Is admitted to include as an insured the landlord, the person or organization that happens to be named. In that schedule, but only with respect to liability arising out of ownership, maintenance, or use of that part of the premises that is leased to the tenant. You go in and lease a building. Do you lease the whole building? No?
No.
Part of it? Okay. Which part? Part of the structure? Do you lease part of the parking lot? Do you lease part of the storage area? What? You guys have leased property?
We have leases.
You have leasees. Let me ask you. In the lease agreement, does it identify specifically all the tenants and their portion of the building?
To my knowledge, it does.
Yeah?
Yeah.
Okay. Would there be any common storage area? How about in your cases? Would there be any common storage areas? Yeah. Do you lease part of that property? In other words, on the lease agreement, does it say that we've leased a specifically identified part of that set of buildings and part of the storage? And the parking lot? Okay. So, the landlord then is added differently depending on what the lease says. In your case, it's a specifically identified unit, right? So your boss, right, your employer, is covered only for that part. So if you have 100 tenants, you have 100 policies, specifically identifying only those areas, right?
Correct.
Okay. In your leases, location to location, you could have something very different. You could have the whole building, you could have part of the building, you could have a building with no common storage area, or you could have part of a building that does have maybe a common storage area. Landlord is only going to be covered in the part of the premises that is actually leased to you. Now, let me tell you where this can go a little messy. This is an example. I got a phone call from a broker up in another state. His insured is one of your tenants, okay? It's a company like yours, you know, that's going in. They're a retail operation. They go into strip malls, okay? This particular tenant is very desirous, actually, of taking care of the landlord. They don't want any problems. You know, they just want to they want to take care of the landlord. They just want everything taken care of, everything, nobody angry with each other, and that's it. Elderly woman gets out of her car. She is now walking to the shop, okay, to the store that has been leased. She falls literally at their doorstep and breaks her hip. She now sues the landlord, okay? Landlord then turns to the tenant and says, take care of me. Here's my additional insured endorsement, right? You have a duty to defend me. Take care of me. So far, so good? There is no status. There is no coverage. The reason the landlord has no coverage is because of these words. Who is an insured? This is on your policy, right? Your policy, all those little 100 tenants, okay? You are covered as an insured, the person or organization shown in the schedule, but only with respect to liability arising out of the ownership, maintenance, or use of that part of the premises leased to the tenant. The tenant leased Suite 101A. The injury took place 6 inches from 101A. I am not kidding. And the claim was denied. The insured in this case was really, really upset because they actually wanted the landlord to have coverage under their policy, and the coverage was denied. They really do mean exactly what they say here, okay? If she had walked across the door sill, right, into Suite 101A, hey, we're good to go. It's a bodily injury, it's not excluded, landlord's covered. 6 inches away, big difference. Do you understand?
That's where the landlord has to carry his own fault.
Yeah, that would be one of the reasons why. Exactly. Because of those situations.
Because instead of saying our additional
That's right. No additional insured status, but the tenant has signed, remember that indemnity agreement we talked about? The coverage did come through under contractual liability. Okay? But there's no duty to defend under contractual. It's simply responding to an obligation that has been assigned by contract. This, they're giving you additional insured status. It's a very big deal.
Can I ask,
You can ask anything, sure.
is there an implied responsibility for the outside area in that usually the leases say in your proportionate share of all the common area, maintenance, upkeep, da-da-da-da?
Unfortunately, unless we identify that as a part leased to you, the answer will be no. It'll have to come back under contractual. It's a miscommunication. It's a miscue, if you will, between the words the lawyers use on what are we talking about the common areas, right? And the part leased is still identified as only that designated suite. That's why I also asked about the common storage, because a lot of times in retail shopping centers, you know, we have maybe a common storage area that's used by all, but it's not identified as a part actually leased to the tenant. They have use rights, but not lease rights. It's a different status. So unfortunately, they will hold to the actual specific letter of this endorsement. And this, by the way, is a standard endorsement. It is just what's used. Any other? That's a great question. What brought that up, by the way? Just a thought process or something specific?
Well, I know that we do have a facility in Florida in which we lease a part of it.
Right.
And so there are other tenants, but I also know that we're responsible, our proportionate share, for
Exactly.
the maintenance of the entire...
Very, very typical. Very. You have two things. Number one, the indemnity language that's in that lease where you're protecting the landlord, and the additional insured status. So one or the other is probably going to respond. Okay? All right. So under the additional insured endorsement, the landlord has coverage for liability arising out of the part of the premises actually leased to the tenant. In a multi-tenant building, I'm telling you right now, that's what you have to look at on all those multi-tenant leases. Do we have clarity? You know, do we really understand what they're saying? Common areas, storage areas, you know, parking lot areas, right, all of it. and also what your expectations are. You know, just because you can say to a tenant, you take care of it, right? You give us additional insured status. You may or may not feel that's necessary in the parking lot, you know, that maybe that's not your thought process, you know. It was actually kind of weird. In the example I just gave you, the insured tenant was actually more upset than the landlord. I know the landlord didn't care because the insurance company's taking care of it, right? They're actually hired the lawyers, they're paying the what was scary to the tenant was that it didn't react the way they thought. They thought it was going to come under additional insured, and I think actually their lawyer looked foolish. I think it was the lawyers fighting it out, because their lawyer said, oh, it's going to come under the, don't worry about it, the landlord's covered as additional insured. Not true, right? They picked it up in a contractual. So that was kind of a weird, kind of out-of-body moment for me, for sure. But, you know, it's just that landlords and tenants have a different view on how these things might work. You might not care, right? This case, the landlord didn't care, the tenant cared. But I've had other situations, believe me, where the landlord did care. And they were threatening to call a breach of the lease, you know, and actually kick them out because they didn't respond. Okay, so a lot of questions remain unanswered, like did the landlord specify the parking spots, the parking spaces, the storage area, common access and public areas? Are they leased or just responsible for damage, right? So we look again at all those different areas. The difficulty is that unless the lease is really, really broad, and that's a very unusual situation, we've got an endorsement that is more restrictive than what the landlord is anticipating. So all I'm saying is match what you anticipate with the actual wording in that lease agreement, all right? I think there's a couple of other issues, and since you guys are predominantly landlords, this I think is an area, are you guys property owners as well?
Mm-hmm.
Yes? Would you have tenants that rent from you as well? Any of the rest of you also property owners? Yes, property owners, where you got tenants leasing from you? Yes? One of the areas that a lot of times...
One's leasing right now.
Yeah, we have one.
You're the ones leasing right now.
No,
okay.
No. I forgot we have a temporary location next to space, but
Oh.
we don't have a tenant right now.
Oh, darn. Darn.
Yeah, I know.
Okay, well, that'll change. Okay.
He's working on
Okay,
that.
you just work on that.
It's had something to do with the contract.
Gee, I wonder what that is. All right, so here's what I'd like you to remember. From a landlord perspective, it's great to have that additional insured status. It cannot be everything, right? You got that, right? Okay.
Already.
And here's a really big reason why. In almost every lease, there will be a piece of language that often comes toward the end of the lease that is called an abatement clause, A-B-A-T-E-M-E-N-T. Abatement means to stop, okay? So an abatement clause is the language that's in the lease that says, okay, when this happens, everybody can walk away from the lease, right? The tenant can leave, the landlord can leave, we can choose to do that. And it usually happens when there's a significant amount of damage, okay? It allows that lease to be terminated. Let me put it this way. As a tenant, I would never want to sign a lease that says, Marjorie, we can destroy the whole building and you still have to pay your lease.
Mm-hmm.
That would be stupid, right? So we want that abatement clause in that lease. But here's the problem. Let's say that we've had this situation. Whoops. The landlord has a fire, and that fire destroys a substantial part of that building. If the abatement clause states that when the building sustains a certain amount of damage, and I just used a very typical kind of example here, greater than 50% to the demised premises, the lease can be terminated by either party. The tenant then says, okay, bye. I can't run my business in this building. It's a half burned out hulk of a building. Bye. All right. Okay, what happens now? What happens now is you don't have any additional insured status. The minute that lease is canceled, it's over. All right? And I'm going to show you one more thing. Let me go back to that endorsement for a second. And this insurance does not apply. This is what the additional insured endorsement says. This insurance does not apply. Gosh, darn it. I'm going to have to take a break here for a second. Sorry, more water. Can you read this?
To any occurrence, which takes place after you cease to be a tenant.
So the minute the abatement clause, it's over, right? The additional insured status is over.
Structural alterations, new construction or demolition operations performed by or on behalf of the person or organization shown in the schedule.
So, got damage? Tenant comes in and says, let's go ahead and fix everything up. You are not an additional insured at that moment. That's what that's saying. Okay, so two things. Stop that coverage. It's just dangerous to rely on this a whole lot.
The occurrence was still before the termination.
Right. Here's the problem. When that damage takes place, right, and the lease is canceled, the landlord is left with a building that's a mess. It's a public nuisance at that point. somebody comes on that property and gets hurt at that moment, you don't have any coverage.
Yeah.
You understand? That's what I was talking about, not the fire itself. Okay, the result of that. Okay. All right, so the landlord is left without a tenant, no income, and no liability insurance. That's what that does to that whole situation. Landlord's protection does not apply in the event of any alterations, demolitions, or construction that take place while they're there. Okay? When we begin to rebuild the same property, no coverage. So again, additional insurance status is great, but it has limitations for when, how long, and what. Oh my God, did you really do that?
Actually, can take
Mr. Safety Loss Control guy is helping me out here. I love that. The dude is prepared for everything. Yay! I love that. Okay. Here's another example. SBE Inc. owns the building. Darla Gray happens to be the stockholder, director, and officer of that company. The lease is in the name of SBE Inc., which is typically how that name insured appears. The additional insured appears the same way. Okay? So just the entity is being covered. Several people are hurt when a retaining wall tumbles to the ground. The injured party's lawyers name SBE Inc. and Darla Gray as executive officer. The additional insured endorsement is only covering SBE Inc. That's very common today. All right, so you'll have those kinds of situations, which is why we look at different wording going on as that additional insured. Now, let's talk briefly about manufacturers or vendors. You said that earlier, retailers, right, that sell your product, you have to list on the policy as being covered. As vendors of other people's products, are you shown as additional insureds on other people's policies?
Yes, you are. Yeah, no. Yes, you are. And we have a book this big of certificates
I love that.
that they religiously obtain and send.
Great. And copies of additional insured endorsements?
Yes. Otherwise, we write to the broker and say,
Hello. All right. Now, let me tell you something. There's a whole lot of vendors out there that do not get that status. They do not. They should, but they don't. Why don't they? I could state the obvious, and I'm going to. This is a very important part. When you guys look at an insurance program, it's a lot more than just the, gee, what are we going to have to pay for insurance this year? It is also, how do you structure and design your risk management? That's the point of this whole thing. By having a book that's maintained, right? By saying, look, we're selling your product. We didn't make your product. You have something go on with your product. You protect us, right? You give us that status. That's your risk management control, saying somebody else takes care of it first. That is really critical. Have you guys done that your entire business career?
Yeah, I can say that.
Pretty much? It's an important thing to do. There's a lot of people out there that do not do that. That's part of that whole insurance process that we have to
But I
do as
think
well.
that many of us, have, and that's what we all here for, is to understand what
Why?
needs to be in a certificate of insurance, specifically. Not just the importance of it, but how do I read a certificate of insurance? Like
Okay.
you said, it's just a piece of paper.
It is. It's just a horrible piece of paper, actually. When you get a certificate, many of you have seen a certificate, yes?
Mhm.
You can bring it up in your mind's eye. What is it that has any meaning to you on that document? Seriously. I mean, it's just a piece of paper. Do you have a checklist that you look at that you say, okay, does it match this, 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 and this? No? No checklist?
Mentally, yes.
Mentally you have. Okay. If I'm going to be listed as additional insured on your insurance, and you say, Marjorie, that's fine, we'll give you a certificate of insurance. The reason I said I really don't care about that piece of paper is it's just a piece of paper. It's a way to memorialize what I want to make sure actually exists. So, on a certificate of insurance, you are really looking for some attachments. What you're looking for is an endorsement like this, right? So when you get listed as a vendor, okay, you got that big old book that you're complying with, okay, what do you want? That certificate of insurance should have attached to it a piece of paper And that piece of paper should say something like this. Cardenas Market is hereby amended to include as, is hereby included as an additional insured. That's what you're after. The certificate of insurance shows you on the general liability coverage, these are your limits of insurance. This is the policy period. And you have been added to it as an additional insured, right? That's what you're looking for. That's number one. Number two, do you have any kind of language on the umbrella? Anything. Typically what you're going to get is an additional insured endorsement on the GL. What you may not get is evidence that shows the same language following through on the umbrella policy. Right? Number three, you need also business auto coverage. Which, by the way, it's true for you guys too.
We have it.
Right? Totally. Okay? Business auto. What are you looking for? I want to know the carrier, I want to know the policy period, and I want to know the limits. Now here's the really cool part. Business auto insurance, you guys have a lot of people that might make deliveries onto your various locations, correct? They're doing so by truck, right? They load and they unload a lot of different stuff, correct? Can people get hurt if somebody it's a pallet of stuff dropped on their head? Okay, that's called loading and unloading of an auto, okay? That's covered on the auto policy. Guess what? You don't have to actually be listed anywhere on that business auto policy. You're automatically covered. So what you want is evidence that they have business auto insurance. Does that make sense? There is an endorsement that you can ask for that you can see attached. It's called a designated insured endorsement. Let me tell you what it says. If you already had coverage, you still have it. That's literally what it says. The business auto definition of who is an insured includes any person or organization that could have legal liability for the actions of somebody who's using that auto. So you got a truck driver comes onto your store, right? They're unloading. Somebody gets hurt. That other party sues you. Could you be held liable for them unloading that truck? Yeah, I know it sounds stupid, but you could be. Right? It's automatically responded to in the policy. You don't have to be listed on the business auto. Okay? But you can get it. You can get the the designated insured.
Yeah, or the big broadening endorsements.
Right.
The standard carriers use.
So you're looking for, do we have the coverage? And that business auto is really critical coverage, especially in your operation. Okay? Question?
Yes, I was just asking because we have radio stations coming on to different locations.
You have, I'm sorry, say it.
Radio remote, like radio stations.
Okay.
And they come to the stores and they,
Oh.
you know.
And you do broadcast, live broadcast.
Yeah, they broadcast, live broadcast and have the bands and, sometimes we have, celebrity appearances. So I was just curious about how that, the insurance works. If it differs from what we're talking about, do we need additional coverage?
Yes, yes, and yes. When the radio station is coming out, they're bringing out equipment, vehicles, equipment, human beings, right? The broadcasting itself, yes? So you have now a lot of stuff that you need. Stop me anytime I'm going nuts, because this is what you guys do, okay? General liability insurance, business auto insurance, we need to be added as additional insured on that. I want an umbrella policy and a big one from these people, and I need broadcasters liability insurance. There's another word in there it's not coming across, but it's the broadcasters professional liability. That was the word that I wasn't coming out of my mouth correctly. The broadcasters professional liability.
That's so. Let's think. How could you get a claim for broadcaster's liability? They have a contest or something, and someone's giving away something, and someone says, I'm offended, and you endorse them coming on, and I'm offended by them, and you are sponsoring this event, so I'm going to sue you.
Right.
And they have a contest, see how many bottles of water you could drink.
Oh yeah, remember that one?
Yeah,
that was a
thinking,
mess.
I was thinking
yes.
of the hot dog eating contest where
yes.
someone chokes.
And we'd also want to make sure that all of these parties, right, the suppliers, the drivers, the event provider, right, that all of them also, they have general liability, business auto, umbrella, and workers' comp.
Now, the workers' compensation, we had a situation with one of your employees being injured at an event, and it was due to the negligence of one of the vendors. Now, we have the insurance for the vendor, and we have a contract for it, but remember, your workers' compensation insurance is going to put the money out there. It's going to affect your loss ratio until there is subrogation back to the other parties, and they're going to get their money back, and that can take a while.
Right? Oh, yeah. Can last take a long time.
Yeah.
Long time. Okay? Now, I'm not done yet because I got some other things that you're going to be looking for on that certificate, but I need to go through the explanation first. Okay? Waiver subrogation. Joe, I spoke about that earlier with the event that you set up for me, you know, where we have other people coming onto the property to do the resistant slip floor and that sort of thing. And I use these words, waiver subrogation. Subrogation is a phrase that is used. It is not unique to insurance, but it is certainly used in the world of insurance a lot. What does it mean? Maria, you just used an example where you had an employee that was injured, right? And your workers' comp paid, but you're actually going after somebody else that is responsible. You're subrogating that loss. Okay, you're looking for somebody else to pay back that was responsible for the act of subrogation. Here's what it actually means. Insurance companies have a legal right established by law that says if somebody else can be held responsible to pay, the insurance company has the legal right to go after that other party instead of making you do it. They take over your legal right to go after the other party for collection. Now, let me give you a couple more examples. You take your car into the shop to have it fixed. You drive it home, you're happy to have your car back. You go to work the next morning, you step on the brakes, and they fail. You hit the car in front of you. That other person is going to sue you, right? You've damaged their car, you might have hurt them, and you're saying, wait a minute, it wasn't my fault, right? The brakes failed. It was, you know, the repair people, it was their fault. Lo and behold, it was, okay? It still doesn't stop the fact that you're getting sued, right? Your insurance company says, okay, we'll protect you, we'll pay for you, no problem. Do you have a legal right to go after the auto repair people and say, you caused this because you did your work wrong, right? You have that right? Okay, the insurance company has protected you, they've paid that other person. The act of subrogation is simply the insurance company steps into your legal shoes and they go after the repair guy. Say, pay us back. You know, we wouldn't have had to pay out a dime if you'd done your job right, right? But your actions caused the injury or damage. Therefore, we've paid out, we want our money back. That's the same situation you described with the employee that got hurt by somebody else. We pay it out under workers' comp, and then the workers' comp carrier says, we step into your legal shoes and we go after the person that caused the harm. You okay with that? That's all that's referring to, okay? So waiver subrogation. Between a lot of parties out there, we don't want to have that happen. We don't want that infighting to go on. So, the employee that comes out from the temporary staffing agency comes out to see you, to work at your place, right, and is injured at your place. They have workers' comp that pays them, right, for their injury, takes care of their medical. The reason we want a waiver of subrogation in the contract is, and in the insurance itself, is to say, look, other person, you go take care of your own employee's workers' comp. Do not come looking to us to pay us back. All right? So now, on that certificate of liability insurance, if the contract says that the insurance will include a waiver of subrogation, guess what? You need to see that. And it needs to be shown on the GL, on the business auto, and on the workers' comp. All of it. Not just one policy, all of them. So I would be looking for a waiver under the GL, under the business auto, under the umbrella, and under the workers' compensation, all of them.
And you're talking about staffing companies.
Say it again?
Staffing companies. Are you talking about just staffing
No,
companies?
no, no, I'm talking about everybody, just in general. But I'll specifically get to that in the staffing people in about 5 minutes.
From certificate of insurance, you can have that, you have waiver subrogation?
I'm sorry, say it again?
On the certificate of insurance, you can request the waiver subrogation?
You know, herein lies part of the problem. I don't care what's written on that certificate. It is irrelevant and meaningless. We use it to memorialize the limits of insurance and the fact that the policy exists, right? But it's only being memorialized on the date that the broker actually issued that certificate. So if that certificate went out on, I don't know, May 1st, then on May 1st I know they had $1 million of occurrence coverage on their GL. Anything else, I don't care what's written there. I don't care, you know, down in there in that big old box where it will say, Cardenas Market is hereby added as additional insured. I don't care. I don't care. I will never care. You know what I care about? Show me. There's an old saying, pretend you're from Missouri. The Missouri is called the show me state, right? Mm-hmm. Missouri people from Missouri say, I don't care what you tell me, show me, right? Mm-hmm. Show me the endorsement. Show me the additional insured endorsement. You got a waiver subrogation that's required? Show me the waiver subrogation endorsement. I don't care about it being written on the cert. I want that endorsement. Okay? I want the endorsement from the GL. I want the endorsement from the auto. I want the endorsement from the umbrella. And I want the endorsement from the workers' comp. The workers' comp one is the one that is going to cost that other party some money. Mm-hmm. Okay? There is going to be a fee for that. All right? I don't care. Okay? If I've got it in the contract, then it has to be abided by. Correct? But I'm looking for the documentation that is attached to that certificate. Okay? I don't care about, you understand? You're going to get the cert. That's fine. God bless you for getting the cert. I care about the endorsements that have to go with that. All right? That was actually the third thing I wanted you to take away. Are you guys all okay with what I just said? Mm-hmm. Everybody understand? I want that little piece of paper. It's going to be about that one. Okay? And it's going to be, I hope, stapled to that cert or sent to you electronically in a PDF. Does that make sense? I got to tell you something, you guys. Getting some of this correctly is like pulling teeth. And you will have to go back and back and back and beg and plead and cry and, you know. You would think that it's very clear. Give me the endorsement. Somehow those words never come across very well. All right? Yes. Talk to me. No, no, no. Don't apologize. I just want to know, can I help address something?
We were just talking because we had an incident a couple of months ago, towards the end of the year, last year, and it was an incident that was caused by an actual temporary employee that kind of like mixed, chemicals. Mm-hmm. Accidentally, he grabbed the bucket, not knowing that there was waste. He actually poured in some, acid, and it basically created this,
phosphorus, yes.
So then everybody just started yelling, there was toxic,
Yes.
everybody went out. Nothing happened major, nothing.
Okay.
And just not too long ago, we got an actual bill of hazmat issues.
Oh, yeah. Now, who pays? Who pays?
Their paying.
Why?
Because I called them.
Good woman. That's what I wanted to hear. That's what I wanted to hear.
Actually, I called Maria, and we don't know how to approach this. What should I tell the agency in my first case? So I called Maria, and Maria says, well, you know what? It's a good idea. Let's call them and say, let's go hands on it. So when I called the guy, and basically I called the risk management department, and the risk management department, like they said, I'm sorry, we can help you with this. If this is something that your insurance has to pay, because you do have workers' comp insurance, and because it did happen in your building, you should have a workers' comp, and this should be reported to them, and you should be paying for it. And I told them I totally understand that it is our building, but at the end of the day, it's your employee.
Right.
The fact that
Adam.
the employee didn't work to what he was doing does not make me responsible.
So I think the lady said, you know what, let me get back to you on this. So then like maybe 15, 20 minutes after, I get a call from the owner
Yes.
of the actual staffing
Mm-hmm.
agency. So we came to an agreement and he said, you know what, I'm going to go ahead and pay it off. So we didn't get stuck with it, but now, of course, because we want to keep the relationship
That's right.
with the business,
That's right.
give you a little bit more.
That's right. So you made a business decision that worked out actually favorably long term. What did you learn from that situation?
That there's always a solution that we can get away from it and not pay.
Damn, I like this girl.
And at the end of the year, I guess, we basically meet our goals as far as saving money.
I doubly like this girl. Okay. Anything else?
We didn't pass it.
No, we did, but it was not
You know, part of what I've got in your material, and it's part of what you can look at later, is actually a listing when you're working with staffing companies, PEOs, of things you have to be careful of. That's actually on the list. Who pays fines, who pays penalties, who is responsible. You know, part of the problem that we run into using staffing companies, which I'm going to get to in about 2 minutes at the most. I got one more thing to go over and then I'm going to get there. Is that we treat it as a very casual relationship, right? They're just sending bodies to us. It's a lot more than that. And it's a very, very big deal. And the difference between a temp and a leased is enormous. I teach 4 hours on only what is a leased employee. 4 hours just on that one topic, all over the country. So this is a huge deal. So I'm doing about that much of it, but it's a very big deal. So understanding the contract first, and secondly, the duties that are spelled out in that contract. That's why he actually paid. Bet me. I bet there's something in that contract. The last little thing I want to go over here is the primary non-contributory. This is another endorsement, all right? Here's what it means. When you have been added as additional insured to somebody else's insurance, we've said several times, you have to have your own insurance still, right? You have to have your own liability coverage. Hey, great, you got status on somebody else's insurance policy as well. That's great. Here's what you got now for you. You got 2 insurance policies. You got your own, right? You got the other one that you're added to as additional insured. So far, so good? Mm-hmm. Okay. I'm going with what you said. I want to make somebody else pay, right? I don't want my insurance to pay. I want yours to pay. So far, so good? Mm-hmm. Here's what this endorsement says. When you are added as additional insured to somebody else's insurance, that other insurance policy says, we agree that we're going to pay first and that we are not going to look to your own insurance to help pay for that claim. So, I'm added to your insurance as additional insured, right? I have my own insurance. I have your insurance too. This is an endorsement that goes on your policy that says your insurance is going to pay first for me. And they're not going to look to me, to my own insurance, to help share that claim. So that huge book that you've got, right, as a vendor, when you get all of those certificates from those vendors, here's what you're looking at. Excuse me. You're added as a vendor to the other party's insurance. You're looking for an endorsement, and that endorsement is called primary non-contributory. And that endorsement should be on the general liability policy and the business auto policy. Both. Not just the GL. It should also be on the business auto. And here's what you say, right? When you get that documentation in your hands, that is an endorsement that says ABC Insurance Company is going to treat Cardenas Market, right? All of you guys on that insurance and pay first, totally. And will not look to your own insurance program to help contribute to that claim. But it is an endorsement, you guys. You will get all the time a primary non-contributory endorsement from the GL insurance company, right? So you've got now 3 things. You've got a certificate. It shows GL coverage. It shows business auto coverage, it shows umbrella coverage, and it shows workers' comp. Yes? Okay? Attached to that certificate is an additional insured endorsement. Correct? Plus waiver subrogation for GL, business auto, umbrella, and workers' comp. So far, so good? Now you got a third endorsement that has to be attached. GL, business auto. And that third endorsement is going to be primary non-contributory. You know what we need to do after class? I'm going to work up a little checklist because we don't have it in the book. And I think we need it. Okay? I don't think I put it in here in this way.
We have you've got other checklists, but we can add the checklist. Also, we can give you, there's some examples of actual contracts. And everyone who's attending, I will send you a digital copy so that you can have your own copy.
Right. I want to add something to that, okay?
But we'll hold off on the digital copy.
Yeah.
And we'll let her finish.
Let me add something to this,
will
okay?
start at 5 o'clock.
No, what I will do, okay, I'm going to add a little sheet, okay? I'm going to tell you, on the certificate, okay, when you have general liability coverage, if the contract requires additional insured, you should see an endorsement, okay? You should also see an endorsement for the primary non-contributory and waiver subrogation. That's 3 endorsements just on the general liability insurance. Do you understand? Then if that contract also requires them to have business auto, then I'm going to expect you to see another set of endorsements, another waiver of subrogation, another primary non-contributory. Do you understand? But on the business auto, you don't necessarily need that additional insured endorsement. Do you understand? Because it's automatically built in. That's what I'm getting at. It gets confusing, doesn't it?
Yeah.
When I got to the primary non-contributory, I did not include workers' comp, and I didn't include umbrella in that statement, because you don't need it on those policies. Right. Okay, so I will send you a list, and I will tell you what to look for and what to expect.
All right, so
Okay?
we'll
I'll do that tonight.
We'll
That's
have
no
that
problem.
list. I think your next section is on the
The temp.
outsourcing of employees, which we've covered quite a bit, and you do have a very good checklist there.
Yeah, I tried to put that in because I knew we would
And
start getting close on the
included in that is
time.
going to be the employment practices liability,
Yeah.
the crime coverage, so those are important. But why don't we do this really quickly, because I'm trying to be concentrating on your time. Why doesn't everybody go grab a sandwich,
Okay.
and something to drink, and then we'll do the wrap up while you're eating.
That's good.
Okay.
That's good.
The
I
sandwich
actually
is
don't
all
have very
labeled.
much left to go
Yeah,
over on the
right.
staff and stuff, right?
What's your step?
Okay, well, I can stay.
Come on, where are you?
Feel better? It just was right. Very helpful. Good.
Yeah.
We have so many issues, so many areas. Yeah, yeah.
Yeah, like I said, if I run out of time.
So, they are on the label, and, this is turkey, and I think this is the, Papa Mario's Italian Deli.
Vegetarian?
Unfortunately, this mouth can go all day. And often does.
There's drinks in it.
Yeah, okay. Yeah, I could do it. Oh, yeah.
Water, water, water.
Water, water.
I didn't know that.
You see the receptionist find her way down to the restroom?
You know, I was wrong. If you walk out, sorry, if your first left is a reception, and as you're walking through the door, you'll see bathrooms off to the left in the lobby area. So you don't have to use the one by the elevator.
What? And you are? This is the meeting.
That's why I was standing for a while. My ABD Joe, and I got a chance to jump up.
Yeah. you're kind of like in the
Great.
middle. You've got
Doing a great job.
your
It's awesome. This could
customers
be
who are
a
demanding,
8-hour
like
conference.
they should, the things that they're demanding.
Believe me, it is.
And you, on the other hand, are
I'm gonna
subbing
just
out
pause
stuff
it for a
and
second.
you demand
We're on 42.
yeah. And
Just so you know, I
really
only got Okay, while you're chewing away, I'm gonna wrap up my little and conclude my little part of this, okay? So you can just continue on after I'm gone. Darla asked me to pay particular attention to the issues of using outsourced employees, whether it's labor lease or whether it's temp. And there definitely is a difference between those two categories, right? So in the world of staffing, if I'm going to a company and saying, I need a temporary person, right? I need 20 bodies, right, Joe? Is that what you were talking about earlier, where I just need 20 bodies for a week or a month or whatever it is? That's a temporary employee, where the PEO is the general employer. The PEO is the professional employer organization. That is a term within that industry that is used all the time, okay? So the staff leasing company, they're a PEO. Okay? So the PEO is the general employer, and you would then be the special employer. In a labor lease, it's a different animal. A leased employee is not just for something that is temporary or to fulfill a temporary needs situation. This is where we actually go to a company and say, for the next year, I want a contract with you. We need 100 people, right? So it's not fulfilling a specific need, right? You're actually performing a long-term lease arrangement with that other company. They're still called a PEO, but it's a different contract. In most states, common law will hold that the client is considered to be the common law employer. If the PEO fails in their duties, fails in carrying workers' comp, fails in doing all this stuff correctly, then the contracted party, that would be you, will get to be their employer, period. That's how the law works. The borrowed servant doctrine into common law, and this is temporary staffing especially, okay? We've got 3 criteria. You are borrowing the servant of somebody else, and yes, that language is still used today. Express or implied contract of hire between the employer and the special employer. So you have a contract, verbal or written, I don't care, between the staffing company and your company. The employee is engaged primarily in work for that special employer. Okay, coming to work every day, right? Working for you. Okay? You tell them what to do while they're there, you know, and then they go home at night. The special employer controls the actual work, details themselves. Well, I was working through it. It can be modified by statute or common law as well. Either party typically can carry the workers' compensation. When I'm using a temporary staffing company, do you guys get any kind of documentation that they've got workers' comp coverage? Do you assume that they have workers' comp coverage?
Well, you just make a phone call, and they send somebody.
Hi, send us exactly. Send us a body, right? Send us 10 bodies. Send us 100 bodies, whatever it is. Can't do that. You can't do that. This is so dangerous to work this way. So, develop a relationship with that staffing company, right? You already indicate you got that relationship going, yes? Document their own protection for their people. Make sure that they have workers' comp coverage. That they should have it. And yes, by God, I want that waiver subrogation from those people, right, on that workers' comp policy. And yes, I want to be listed as an alternate employer. Because if that employee can get hurt on the premises and come back and say, I inhaled that bleach, I don't care that I caused it, right, and I want to be your employee too, I don't want them suing you for it, right? I want the law to recognize you as the alternate employer and have that status on their workers' comp coverage. Does that kind of bring it down? Okay, to basics for you. Good. Okay, that's really important. Now, I got to show this to you. This one is really long, and you don't have to read the whole thing. I'm going to read you part of it. If you ever get yourselves involved in actual labor lease, not a temporary staffing, right, but an actual labor lease, you have to be really aware that the law differs state to state on this issue. I think this print is so tiny in your book you'll never be able to read it, right? Ever. But you'll get the digital copy. So, okay. Here's the point. This is only California. This is not any other state. This is actually unique in the United States. Yay. And it happens to be in California. Here's what this thing actually says. In the California Labor Code, okay, we've got Section 3700 and subsection D. Here's what it says. The staffing company, the PEO, in a labor lease has to be the one to buy the workers' comp. Okay, so they must provide the workers' comp. The second point is that the coverage remains in effect for the duration of that labor lease arrangement, providing legally sufficient coverage to the employee, of the employees who form the subject matter of the coverage. That agreement shall not be made for the purpose of avoiding somebody's experience mod. Gee, I never took care of my own employees and my experience modification was huge, so I'm just going to send all my people over to somebody else and we'll call them their employees instead. No. Here's the other bottom line. In a labor lease, I'm going to say it again, this is not a temporary staff situation. This is a labor lease situation. You, as the co-employer of these people, you're not a special employer now, you're a co-employer. You would be protected by the workers' comp that this law requires the staffing company to carry. All right, the labor lease company to carry. But what if that labor lease company doesn't renew their workers' comp? Doesn't pay their monthly audit? You will never know it. That insurance will cancel and you will never, ever get notified. Do you understand? Even using that alternate employer endorsement, you will never get notified in the event of cancellation, period. Now guess what happens? In a labor lease situation, you, the co-employer, become legally liable. Here's the worst part, right here. As long as the labor contractor, employers, that's the labor contractor, who has complied with this subdivision will not be subject to civil, criminal, or other penalties for failure to provide workers' comp. That would be you using the labor lease company, right? You recognize that the labor lease company has to buy the workers' comp and that you're deemed a co-employer and you are protected as a co-employer of that person. But if they cancel that insurance, you can, in the absence of compliance by the labor lease company, be subject to all three. Here's what that means. That same employee that came along and mixed that bleach up with that other chemical and caused that cloud, right? Let's say that was a leased employee, not a temp, but a labor lease situation. And their direct employer had allowed their workers' comp to cancel. That employee can absolutely sue you. They do not have to treat you as an employer, right? And then you would turn the claim into your own workers' comp. They can sue you under tort. Remember in the beginning when I talked about tort? You will have no insurance for that. Anywhere. Nowhere. It is excluded. It is excluded under the workers' comp. It is excluded under the GL. It is excluded under the umbrella policy. There will be no coverage for that leased employee injury suit against you ever. No. It is, no. You know why? No. You've got an injury to an employee exclusion. See, the minute you bring in, what you're trying to say is that the who is the insured clause includes the leased employee as a defined employee. That also means the injury to the employee exclusion applies. You're done.
Okay, I gotcha.
You understand?
Yeah.
Temp, yes. You're good to go on the temp, but not on that leased employee situation. There is an endorsement in injury to leased employee. You'll never get it. Never. To change that. There is zero coverage for this situation. I think the labor lease situation is probably the most dangerous out there because it's entered into very lightly, usually not for any really good reasons, an attempt to save money. And let me tell you something. Even when you use temporary staffing, right, different situation, which you are doing, the temporary staff, you have so many issues that are not being addressed. I don't have time in this class to tell you all of them.
There is a checklist.
That I'm going to show. That's why I'm going. Don't worry, Mom. I'm going. I swear to God, right now, I'm going there. All right. Short list. If you are using leased or temp, I don't care, right? All of this applies. You have to think about all of these. If the leased worker causes third-party loss, whose insurance actually do you expect to respond to pay that injury? You had that situation, right? And you worked it out. Business auto. Who screens that employee? Who looks at their driving record, right? Who makes sure that they're doing the right thing? On the workers' comp, add that alternate employer endorsement. Waive the insurer's right of subrogation. You want that waiver of subrogation endorsement, therefore, right? Clarify the contract about who is going to be responsible. If you're using leased employees, you've now got a situation where you have to clarify exactly whose experience mod is going to apply, if you're going to have one that applies. On the umbrella, do we have the same kind of definition? You know, you just mentioned, Carol, on the definition of employee. Is it following form on the umbrella? I don't know. Maybe they could be all different. Fiduciary. Okay. When you have, do you guys have any temp employees that have actually been there for a long time?
Yes. What's a long time?
I don't know, more than 6 months.
6 months to
Yeah.
a year?
Sure. A lot of businesses do that today. Do you think that they think of themselves as being some kind of weird temp? Or are they just coming to work every day? They're looking at Joe, talk to them every single day. If they get hurt, right, or they have benefits that are not provided to them the way that they think it should, do you think that temp could ever either sue you for harassment, discrimination, or failure to provide benefits? When that's not your role, right? You looked at the staffing company to do all that. Do you think that could ever happen?
It has.
It has happened. It is absolutely legally allowed to happen.
And that's after a
So,
couple of weeks.
I know. Oh, trust me, I know. I've seen them all. All right, so here's my question then. When did you look at the temporary staffing company's employment practices liability? When did you look at and make sure that they were carrying fiduciary liability, employee benefit liability? All of those areas are vulnerable. You are vulnerable to them suing you. Now, in your own insurance program, we have definitions to include these people as covered persons. I just don't want it to pay. Does that make sense? I don't want you to be vulnerable to these areas. You've got intellectual property, especially your company. You have massive intellectual property, trademark items, copyright items, etc. Okay, so if that temporary staffing person steals those ideas, who do you go after? Right? Their employer? I would hope so. Does it say that in your agreement? Probably not. If they steal, now what? They're stealing from you. They're not stealing from their boss. They're stealing from you. Where's their coverage for that? I asked that staffing company to prove to me that they have crime coverage. I don't care. They've got employee dishonesty insurance that pays if the employee steals from them. We're talking about the employee coming to your property and stealing from you. Do you understand? That's third-party employee dishonesty. It's an endorsement. It's actually very difficult to get, actually. Same thing on the EPL. You have to ask these questions. You have to look at it. So I'm gonna kind of wrap this up. I did the IP already. Let me just say that the bottom line here, and forgive me, I'm kind of doing it down and dirty, okay? Most of the time, we use staffing companies to save time, money. I don't want to be responsible for hiring all these people because I might have to fire them and then they're going to sue us for wrongful termination. So we do these for many good reasons. It's also very challenging from a risk management situation because the law actually doesn't recognize you as anything other than their employer. And you are now their employer with no control. Do you understand? You have no ability to do background checks. You think somebody else has done it. I don't care if they're temps or they're leased. You will be treated at some point as that person's employer. Okay? Your insurance doesn't always treat these people in the same capacity as a direct employee. That's a problem. So you got to make sure your broker, is doing the job on that. And on the flip side, you need to put a lot more emphasis on those contracts. Okay? Then they're very casual about those contracts. Okay? Take a look at them with a very hard eye. What are they providing? What are they showing to us? And what do we have to get from them? Okay? I'm all done. Thank you. Yes?
Can you give an example on the employment practice?
I'd be happy to. I've got a perfect one for you. This happened with one of the brokers I worked with a couple of years ago. Woman comes to work. She is there one day. Comes to work on time. Everything is great. Next day she's late.
Is it a temp employee?
Temp employee, not a leased, a temp. Okay? The woman is late the next day. Supervisor doesn't like that very much. Next day, she doesn't show up at all. Supervisor calls the temp company and says, you got to send somebody else. You know, we just can't have this. You know, we expect the person to be there, the time that we want, etc. And they do so, right? So they get another body out there. Life goes on. 4 months later, a lawsuit comes in the door. This woman was suing, and she sued the staffing company and she sued the client, right, the company using the staffing services. Why? She claimed discrimination. Apparently she was late that morning because she'd gone to the doctor to find out she was pregnant. The next day she is throwing up. Sorry for the lunch. Sorry. And so she says, now, here's what you don't know happens. Staffing company gets on the phone, leaves voicemail after voicemail for this woman. You were late, you didn't show up, you're going to cost us a client, this is a very valuable client. So instead of just never using her again, right, like they have the right to do, they kind of harangued at her a little bit and it made her mad. So she filed a suit. Now, you had no control over that, right? You didn't even know that happened. It all came out later. But that was a suit filed against both parties. Okay? And I will tell you, we lost. We actually didn't lose. We settled out. You know, wrote a check for $60,000 to say goodbye. That's losing. In my book, that's always losing. Goodbye. Bye-bye. Pregnant woman in front of a jury. No. Bye.
Oh.
Bye-bye. Bye-bye. Right? Upset the poor pregnant woman.
Thank you.
You guys have been lovely. I'll take you as students anytime. Thank you very much. Take care. All right.